little bit more. That's fine. That's fine, that's fine.
My God, it's a packed courtroom. It's like we're giving something away. What's going on here? Whoa. A couple of preliminary announcements. One, Judge Pitt Burke, as you can see, is on camera. She's here virtually. The other is that we have a number of interns from a number of law schools here within the city of New York, as well as the state, and a couple of colleges as well. So we want to make sure we're on our best behavior, so they still want to become lawyers, right? They're not tarnished at all. We have a packed courtroom. We have a lot of cases on today. According to this, it's 6 hours of argument time requested. So please, just request the time that you believe that you need. Keep in mind, again, we are familiar with your briefs. We've read them. Again, just ask the time that you think you actually need to argue. People v. Dwight Smith.
Appellate request 6 and 2. Respondent request 5.
525. Kenara versus KESY LLC. That matter is adjourned. AM Children.
Respondent appellate request 5.
4, 3, and 3. Merchants Cachet versus Roche.
Appellate respectfully request 6 and 2.
Respondent, I guess 5, Your Honor. Unless you have more questions, I'll answer.
Yes, keep in mind, if we have additional questions, we will certainly ask them. 5, 2, and 5. FGP1 versus Dubrowski.
Yes, for appellants, Mark Schweitzer at MIC, we would like to submit on the papers.
Yes, and I had noted there was no respondent, so that matter is submitted. Thank you. People of New York versus Trump.
For appellants, 7 and 4, please. Your Honor, I represent Ivanka Trump only. I was prepared to submit it. That was before I knew about the 6 hours. It was for judicial economy. I advised the Attorney General. The response I received, I want to put words in their mouth, was to the effect of, well, we can't control if the panel asks us about your client, and therefore we're not willing to likewise submit. Therefore, I haven't submitted. But if my understanding would be that if I did submit, and the Attorney General likewise submitted on my client's appeal, there wouldn't be questions. But if there were, of course, I'd want some time.
Could you repeat that? Attorney General, what do you want?
I was going to ask for 8 minutes total to respond to questions that the court has on either of the appeals. I think it's a little hard for me to limit.
Okay, so we'll do 7 and 4 as requested by you. I'll give you like 5 minutes, okay? And then the AG's office, you want 7 as well?
Or 8 since there's 2 of them.
Okay, 7 for you. Thank you. People versus Tavares Gaston. That matter is submitted. So we have two appeals now. Friends of Elizabeth Street versus the City of New York and Elizabeth Street versus the City of New York. Those will be argued together. She said for the City Appellant, 6 and 3.
For the remaining appellants, rather, I'm happy with that too.
Respondent? Okay, so we have 6, 3, 2, and 6. People versus David Coleman.
Defendant appellant requests 4 and 2, Your Honor.
4, 2, and 4. Victor RPM versus Charles Condominiums.
Appellant requests 5 minutes.
3 respondents.
You don't have a cross appeal, appellant? You don't want time in any rebuttal, right? You 5. You just want straight 5?
Yes.
Okay, 5 and 3. Ventura versus Lubman.
Defendant appellant, there was no respondent brief filed, so I'd like to submit it.
Thank you. That matter is submitted. People versus Rashawn Davis. Judge Pitberg is recused on that matter.
The people respectfully request 4, Your Honor.
4, 1, and 4. Schatz versus Shertock. 5, 2, and 4. Rodriguez versus Diaz. That matter is submitted. Ballantyre Court versus versus SNRP West. 5, 2, 5. First matter for argument, People versus Dwight Smith.
Good afternoon. May it please the court. Matthew Bova for Mr. Smith. We're back. The trial court yet again violated Mr. Smith's right to counsel. The necessary and appropriate remedy for this violation of his fundamental right to counsel is dismissal of the indictment.
So your client has already served his sentence, is that correct?
Yes, Your Honor.
And in this instance, you're claiming that there was a violation of the Sixth Amendment because there was a conversation between the judge and the defendant, and counsel was not present during this conversation. Is that correct?
Well, yes, Your Honor. But the conversation was substantive. I mean, the conversation was about the court and the prosecutor's position on the minimum plea available in this felony.
Right. So the court stated to the defendant that the court was unwilling to sentence the defendant to anything less than 15 years, and I believe stated that would not even entertain a lower offer or lower sentence by the prosecution. Is that correct?
Yes, Your Honor.
So my question then becomes, under the relevant case law, how did that exchange? And I'm not really sure why the court had this exchange with the defendant, without counsel being present. But anyhow, how did that exchange in any way substantially impact the defendant's ability to defend, which I believe is the test, right?
Well, under the statutory test, the standard is simply whether it is a stage of the action, and CPL 1.20 sub 16.
Oh, don't we need more than simply a stage of the action? I mean, doesn't it have to be a relevant stage of the action of the proceeding?
Under the state and federal constitutional standard, it's whether counsel could have played a role at the proceeding, whether counsel's presence would have affected Mr. Smith's due process rights.
At a critical stage, correct?
Yes, Your Honor.
And so the question is was this a critical stage of the proceeding where the judge made probably a remark that should not have been made?
Yes, it was a critical stage because Ashe and its progeny, including People versus Garcia, define critical stage as a stage that counsel could have played a role at. And here, the court locked Mr. Smith into the belief outside his attorney's presence.
How?
Counsel, if I
Sorry,
can,
go ahead.
if I can, your client didn't plead guilty that day, correct?
No, he pled guilty 2 weeks later, and that,
Right, and at that time, even though it was ill-advised, with the court's comments, the court did indicate that it would give your client an opportunity to speak with counsel, correct?
yes, the court generally said that, but the problem
And
is,
then when he did plead guilty, he acknowledged that he spoke with his attorney, and that was 2 weeks after.
yes, but the problem is that there's no evidence whatsoever, and it would be pure speculation to conclude that counsel was made aware of what happened at the January 15th proceeding outside of his presence. Counsel needed to know, and I think it is a simple rule of justice, that counsel needed to know that the court was having a conversation with his client about the minimum sentence available. Mr. Smith was eligible for a sentence of 5 years. A sentence of 13 years would have been time served.
So at the plea, right, prior to pleading guilty, the defendant acknowledged that he had spoken with his attorney concerning the plea.
But that doesn't cure or address the problem, which is that the court told him outside counsel's presence, I will not go below 15. What Mr. Smith needed and what the Constitution demanded was counsel there, so counsel could tell.
So at the sentencing now, right, excuse me, at the plea, counsel states that the defendant wanted to plead guilty to manslaughter in the first degree with a promised sentence of 15 years incarceration and 2.5 years post-release supervision. Where did counsel get this from, if not from his client, who informed him as to what the offer was?
Well, no, the counsel was made aware that the position of the court, that the 15-year sentence was the available deal. But what counsel didn't know is that outside his presence, the judge is telling his client, you can't do better.
So I don't know, so what's the problem with that?
Because counsel could have then said to his own client, he could have said, no, we can do better. That's my job.
Okay, so what precluded?
Couldn't that have occurred regardless, right? Isn't that what the attorney is there for, to advise, well, these are all of your options?
No, because defense counsel doesn't know that he's operating with a client who's been locked in to a particular understanding of the minimum sentence outside of his presence.
I am not understanding how the client is locked in, nor am I understanding why on the subsequent date, when the defendant does in fact plead guilty, why at that time there could not have been further discussions, negotiations concerning the plea and sentence.
Because what counsel needed to know is he needed to know that he was dealing with a client who was just told that better than 15 is impossible. He could have told his client, I steer the ship as far as plea bargaining.
But wasn't the 15 years always the offer? I don't think the people had ever offered anything less than 15 years. And we're keeping in mind that this matter had been up on appeal, and then it was remanded back for further proceedings.
Because the court tells Mr. Smith, 15 years, no better. I will not go below. But what could have happened, though, if counsel knew that that's what he was dealing with, he could have also told his own client, Mr. Smith, if I can get the prosecutor on board to go below 15, Justice Barrett will do the same thing most likely.
Go ahead.
This seems entirely speculative to me, that that's what would have occurred.
Well, it's not speculation, because the standard is whether on this record counsel's presence might have mattered. We don't need to show that counsel's presence would have changed the outcome of the proceeding.
No, it's not might have mattered. It's whether or not there was a substantial impact on the defendant's ability to defend.
Well,
but you have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Elliot Hamilton for the Office of the Bronx District Attorney.
Counsel, let's assume, for argument's sake, your adversary is correct. And that there arguably is a violation of the Sixth Amendment. What would be the appropriate remedy under those circumstances?
Your Honor, in a situation regarding remedy, the remedy in what I would imagine my adversary is asking for is that
I'm asking you, what is the appropriate remedy?
I believe that the remedy would be to vacate the plea and bring it back for further proceedings. knowing that the judge in this matter has since retired, and if there's any question about the potential prejudice that would have occurred if this happened a third time, would not occur again.
I don't think whether the judge has retired or has not retired is really something that is a factor. And I thought that it was either vacator of the plea or dismissal of the indictment. And the defendant here is arguing that the indictment should be dismissed.
And I believe that that is an extraordinary remedy that is not warranted in this, notwithstanding the fact that this was not a critical stage of the litigation. At this particular time, the question was this was a status update. This was whether it was an update as to whether this was going to be.
Counsel, excuse me. I mean, for those of us who have practiced in the criminal court, one might not want to have such a conversation with the defendant, a status saying we're adjourning your case, maybe. But what about your adversary's position that the defendant might have felt locked in to 15 years and not even thinking that anything else was a possibility?
We have no records suggesting that the defendant wanted to withdraw his plea or file a 440 motion indicating that counsel was ineffective in trying to negotiate a lower plea. And at that appearance, it was clear from the prosecution that the lowest that they would be willing to go was 15 years. When a defendant is looking for a plea to a lesser included, the only way that happens is if the prosecution agrees to the lesser included as well as the court agreeing, accepting, or rejecting it. All the judge did in this particular case was advise the defendant as to where the negotiations were outside of the court appearance. These plea negotiations occurred outside of the court's presence, and all the judge did, though it was better that he said nothing at all in our position, all he said was, this is where it is right now because the prosecution is not willing to go lower, and the judge has discretion to accept or reject pleas on lesser included offenses, especially with a homicide.
Shouldn't counsel have been present during this conversation, during this back and forth with the defendant?
This all would have been better unsaid by the court, but nonetheless, it is still not a critical stage of the litigation in which defendant's right to counsel was violated. It would have been better off if the court had just merrily adjourned it. And the court further stated in this appearance that he was under the misimpression that his attorney communicated the defendant's position to the prosecution in the course of the plea negotiations that happened outside of this court appearance. And as soon as he recognized that there were miscommunications between the defendant and counsel, that was when the judge stepped back and said, I speak with your attorney. We're not binding you to any plea negotiations at this particular period in time. We're going to adjourn this case, have a conversation with your attorney, and then attenuation now attaches where after 13 days after this appearance, defendant does take the 15-year plea. He does acknowledge that counsel that he was satisfied with the representations of counsel and did not bring up anything either at the plea, at the sentencing, or in future filings, because there were no future filings, that there was an issue at law in which the plea negotiations were tainted and the voluntariness of his plea was tainted by the judge's less than ideal statements that he made. And it's our position that this wasn't a violation, that this wasn't a critical stage of the litigation. He was not harmed by these statements. The voluntariness of the plea is not an issue, and dismissal with prejudice is an overreach of a remedy in this circumstance, especially given this case. And the court has no further questions. We ask that you affirm the conviction.
Thank you. Did we lose her?
Well, isn't counsel correct here? That even if you have a colorable argument that your remedy, because this presumably was done through plea negotiation, your appropriate remedy would be to vacate the plea. Wouldn't that be as opposed to dismissing the indictment?
No, Your Honor, because the standard under CPL 47020 is whether it's necessary and appropriate. And as the Court of Appeals said during Smith Round 1, the Court of Appeals said that you have to make sure that the remedy is tailored to the violation. The problem here is that we have irreparable harm. Mr. Smith was deprived of the opportunity because the court decided to usurp counsel's role, was deprived of the opportunity, and his ability to fight for a better deal was interfered with because of the court's advice to him
I could
outside.
kind of understand that argument if for some reason the defendant had been able to enter a plea of guilty without counsel being present. But it was 2 weeks later, counsel was present at the time that he took the plea. The defendant stated that he had discussed it with his attorney. So I'm not really sure about your argument. And also, I'm wondering other people, our decision in People v. Teron, T-E-R-O-N, which is pretty much kind of what happened in this particular case. And in that case, since the defendant had completed his sentence, we said that we can't dismiss the indictment, and since the defendant was only asking for dismissal of the indictment, we affirmed.
So as for remedy, the reason why dismissal of the indictment is required under these circumstances is that the violation deprived Mr. Smith of the opportunity to negotiate for a sentence lower than 15 years. So what ended up happening was that there's been now irreparable harm because he can't get that back because he has completed his sentence.
Susanna's on the phone. Okay, go ahead. You can finish your thought.
And was only asking for dismissal of the indictment confirmed. So as for remedy, the reason why dismissal of the indictment is required under these circumstances.
Oh, we're getting feedback.
I think that's you, just what you said 3 minutes ago.
Oh. I'm sorry, counsel.
So this violation deprived Mr. Smith of the ability to negotiate for a sentence lower than 15 years. Now he suffered irreparable harm because he can't get that back. He's already served.
It's so speculative that in fact you would have negotiated essentially a 13-year deal and your guy would have been out.
So the standard under People versus Garcia is whether counsel's absence might have prejudiced the defendant's due process rights. When we're looking at a right to counsel violation, we don't require the defendant to make a particular showing of prejudice because that flips the burden. It's the state's obligation to guarantee the right to counsel. It's not the defendant's obligation to come forth, like with a Strickland claim, and show the court, hey, if my lawyer had been there, it is likely I would have obtained this. And what really happened here is the court is interfering with counsel's role as the person who steers the ship with plea bargaining.
Thank you, counsel. Thank you both.
Thank you.
Matter of children.
Thank you.
Whenever you're ready.
May it please the court. Philip Katz on behalf of the appellant. Your Honor, this case is one of many Article 10 cases that occurs in the city each day. But what happened in this case, where a 10 and 14-year-old were removed from my client's care and where a fact-finding hearing was held over the course of multiple days, Judge Millsap, who was presiding over this hearing, indicated in October of 2021 that ACS didn't have enough evidence for a finding against my client. Then what happened on the next court date? ACS comes in with a document. It was a drug test result.
Was your client present during the hearing?
No.
So she absented herself from the hearing, right?
That is correct, Your Honor.
Okay. So she wasn't there.
Yes.
And was there testimony provided at the hearing concerning the condition of the home, the condition of the children, the fact that the one child who with special needs had not had their medication, had not had their services, there was no food in the home, things of that nature? Was that was all of that brought out during the hearing?
So to be clear, Your Honor, a caseworker testified that on one occasion she visited the home. And on that one occasion, she found the refrigerator empty and the pantry bare. And that was on one occasion.
Well, there were also no beds. The 13-year-old slept on the couch. The 16-year-old slept in the bed with the mother and the father. The one child who had autism and an intellectual disability was wheelchair bound. I mean, there was a lot there in terms of the lack of care given to these two children.
I understand, Your Honor, but what you also have from the judge who presided over this case, the judge who heard the facts and was the person who was considering these facts, Judge Millsap, on October 28th, 2021, he turned to ACS and said, I can't make a finding based upon this. We need more. And in fact, there was a colloquy between the court, ACS, the attorney for the child, and it was acknowledged that they didn't have enough at that point. And
I
Judge
thought Millsap ultimately found after an inquest that your client had neglected the children.
That is correct, Your Honor, because what happened was after that October 28th date, he called for one more hearing date to give ACS one more chance to get a record in that would give the judge the information that he felt he needed to make a finding of neglect.
Counsel,
Yes,
did your client had an opportunity to testify in this case, correct?
Absolutely, yes, Your Honor.
And she didn't testify, correct?
She did not testify, Your Honor.
And the judge took a negative inference as a result of her failing to testify?
He absolutely did that,
Okay,
Your
so
Honor.
put that aside. How did your client dispute any of the issues raised by my colleague with respect to providing basic necessities in medical care?
So the answer, Your Honor, is she did not. But
So it's undisputed. So in other words, the neglect, at least as I understand it, then it was undisputed by your client.
the burden of proof is on ACS nonetheless.
I agree.
Number one. And number two, again, I'm going to go back to October 28th of 2021. Even after the Judge Millsap had heard all of that, the court.
No. Did the judge make a finding that day?
No.
No, of course not. So isn't it entirely possible that the judge went back, thought about it some more, looked at the evidence? I know that most of us on this bench have done that. The question really is, isn't it enough to establish the neglect by, regardless of the toxicology report, two, not one, but two visits to the home? In both visits, there's no food in the refrigerator. The father is taking an old sock and changing diapers. All of that was undisputed. All of that, are you saying, is not enough? That regardless of what the judge may have thought in the moment, at the end of the day, the question is, isn't that enough for a finding of neglect?
I would say, Your Honor, that in this case it wasn't. I think we have a very clear record of what Judge Millsap was thinking and what he wanted.
So what? I'm asking you, look at the record. Look at what is in undisputed evidence. You're saying that two visits, no food, all of what my colleague just recited, and the mother and a failure to testify negative inference isn't enough on its own to make a finding of neglect?
I think in this case it was not, Your Honor.
Okay, well, let's go to the medical records, right? Because we have the medical records from Lincoln Hospital regarding the child who's severely disabled, right? And so
Correct.
weighing 49 pounds, September 2019, 48 pounds. The following month, had the stomach flu, weighed 46 pounds, had not attended a developmental appointment in some time. Now, would that be enough?
So, Your Honor, in that particular case, I think it is not enough. And I think in that particular case, there was testimony on the record that with the exception of two appointments, that my client was following up with the doctor. And in fact, one of the appointments that my client missed, there was some testimony with respect to the fact that it was because the child was ill and she couldn't make it on that day.
And then failure to thrive, that wouldn't be enough. So you're saying that's not enough?
I'm saying in this particular case, that was not
Why
enough.
do you keep saying this particular case? I mean, these are the facts that were presented in this particular case. So why do you keep saying in this particular case?
Because you have
What makes it special?
one CPS worker who testified with respect to this. There is no corroboration. There was testimony. There were allegations in the petition about issues with the school and the children, for example, saying that they were hungry when they were at school. Nobody from the school testified. No evidence regarding that was provided. And I believe it was, Your Honor, one visit to the home that resulted in
2 visits,
Two
two.
visits. It was 2 visits.
No
My
food in the
apologies, that's the case.
refrigerator, no food in the cabinets. Also, the same child we're talking about wore diapers. No baby wipes, no diapers.
That was correct on that particular. And
You have
so,
time on rebuttal.
okay,
Thank you.
thank you.
I guess ACS, right?
Your Honor, may it please the court, my name is Amanda Abata and I represent ACS. The family court's finding of neglect should be affirmed as we discussed extensively.
Would the toxicology report showing positive for cocaine, would that be admissible? How would that be admissible?
Your Honor, there's extensive case law, or there's case law that says that records created by contractors can be admitted into evidence if the recipient can establish either personal knowledge of the contractor's business practices and procedures, or establish that the records provided were incorporated into the recipient's own records.
So this toxicology report was incorporated in the report of the substance abuse facility or whatever that the mother was attending. Is that
Yes, Your
correct?
Honor. The CSEDNY, the substance abuse facility, routinely relied upon these records.
Oh, was there testimony with respect to that? I totally agree that if in fact there was testimony from your agency saying that we rely on these records, of course they come in, but it was just a certification, correct? There was no testimony attempting to establish the reliability of the records.
There was a response from the ACS attorney that was present there to essentially.
Well, the attorney wouldn't have personal knowledge, right?
Fair enough, Your Honor.
But they
But
were they certified and delegated under the Family Court Act?
they were certified and delegated.
Right? So under the Family Court Act 1046, wouldn't that satisfy Family Court Act 1046?
But the certification and delegation relates to your own records, correct?
Well,
it doesn't relate to third-party records, correct?
Your Honor, that there are instances where they have been allowed.
But let's put that aside. Put that issue aside.
Okay.
Without the toxicology report, is there sufficient evidence for a finding of neglect?
Your Honor, there's more than enough evidence.
What's the basis of that?
Well, there's the medical neglect specifically. Specifically, in November of 2019, there was an ACD for a prior petition where ACS had alleged medical neglect against the parents. So they were on ACD in 2019. Then there's this petition, once again, re-alleging medical neglect based on all that we've discussed here previously, the failure to thrive, the loss of weight, the failure to make the developmental and gastroenterological appointments for Kimura. And then, of course, there are, as stated previously, there are the 2 house visits where there was no food in the kitchen or the pantry, despite the fact that they received monthly financial assistance. There were no baby wipes. There was the cleaning of one of the children's genitals with an old sock. All of these things combined with the negative inference is more than enough for a finding of neglecting, irrespective of the toxicology report.
And what do you say to counsel's statement that at one point the judge said this isn't enough?
Your Honor, there is some sort of commentary by the judge at that point, but again, as Your Honor stated, he didn't make a finding at that point. There was another hearing date where more evidence was presented and where he had time to consider what was already presented at that hearing date.
Thank you.
Thank you, Your Honor.
We have the attorney for the children.
Good afternoon, Your Honors. My name is Diane Pizarro, and I represent the children in this case. As for the admission of the toxicology report, I do not disagree that it would have been better if somebody with personal knowledge had attested to that the record constituted a business record.
Or was at least relied upon
Yes.
by the agency.
Yes, exactly. It would have been very simple to have someone come in and say they routinely relied on these kinds of records. I don't dispute that didn't happen in this case, and it should have. But putting that aside, there was more than enough evidence before the court to make a finding. And in fact, there was plenty of evidence on the day that the court granted the adjournment to bring this record in.
Is it with the child sleeping with the parent in the parent's bed? Is that sort of an appropriate way to handle that situation with the child with those kinds of needs?
It's not, Your Honor. I have to be candid here. I don't actually think that was proven at the hearing. I think that was alleged in the petition.
Well, that was because there were no beds, right?
That's right. It was
There were no
alleged.
beds in the apartment.
That's right. It was alleged in the petition that there were no beds in the apartment and that one child was sleeping on the couch, one child was sleeping in her parents' bed. I'm not sure that was actually proven at the hearing, but what was certainly proven at the hearing was that there wasn't food in the home on 2 different occasions, that one child, Kimura, in September of 2019, she was at the 8th percentile in terms of weight for her age. In October, she had dropped down to the 5th percentile, and in December, she had lost 2 more pounds. That this child missed at least 3 medical appointments in December. She was not being seen at a developmental clinic where she was supposed to be seen. She missed an appointment at the pediatric gastroenterology clinic because she was ill, but her parents didn't reschedule that appointment for her. She missed an appointment, a pediatric appointment that same month. So she was not receiving adequate care. As counsel noted, there were not diapers in the home for her. There were not wipes in the home for her. And I would also just like to point out that putting aside the whether or not there was a positive toxicology properly admitted as to the mother, as to the father, there certainly was. He acknowledged that he told the caseworker, he admitted that he was using drugs. It was in his treatment records. There was a statement by him in his records that he sometimes used cocaine when he felt frustrated. And as I argued in my brief, putting aside whether there was a positive toxicology properly admitted as to the mother, the court certainly could have made an inference that the mother was aware of the father's drug use around the children.
Could have, but did it?
Yeah, that's a little speculative as well. Thank you.
All right, thank you very much.
Thank you.
Fair enough. Thank you very much.
I think you have 1 minute on rebuttal.
Well, Your Honor, if the court doesn't have any questions, I have nothing further to add at this point.
Thank you. Thank you all. Merchants Cache Investor Partners, LLC versus Robert Roche, or Roche. Whenever you're ready.
May it please the court. My name is Barry Lichtenberg, and I represent defendant appellant Robert Roche. I would like to make 2 points this afternoon. First, this is an unusual guarantee, a guarantee that is inherently inconsistent and internally contradictory. The order below found the guarantee to be unconditional, the type that, quote, without recourse to any defenses, close quote. And that is simply not correct. The guarantee states that it is very much conditional, that its enforcement may be limited by, quote, general equitable principles, regardless of whether the issue of enforceability is considered in a proceeding in equity or in law. And that contradictory language within the guarantee should have precluded summary judgment, Your Honors. A contract divided against itself cannot stand, and this contract, this guarantee, is inherently inconsistent, and that should have been a basis for denial of summary judgment. Yes, that is exactly what the order does.
In other words, you're saying the guarantee wasn't sufficient to make out a prima facie?
It can make out a
There's
prima
no breach of the guarantee in this case?
Yes, Your Honor. There
Yes,
was.
Yes, what? There was a breach or no?
There was no, not in terms of this guarantee. There was no payment under the guarantee. That is not in dispute, Your Honor.
So there was a breach?
There was. He did not pay. Robert Roche did not pay under this guarantee, but this guarantee provides for the assertion of equitable defenses.
Well, it seems to me, okay, that's fine, I accept that. So the prima facie is made out, then you have to raise issues of fact.
Yes, Your Honor.
So what are your issues of fact as to why that would merit a trial on the guarantee?
Okay, well, right. So the next step is issues of fact, and the record provides ample evidence that the respondent knowingly and purposefully lied to Robert Roche in order to convince him to sign off on the put option provision and the guarantee. You can call it fraudulent inducement, unclean hands, detrimental reliance. In fact, respondent commenced 2 actions against Adam Hochfelder, it's in the record, that provides that Adam Hochfelder held a 1/3 interest in respondent, and Hochfelder used his position to lie to investors, including Robert Roche, that respondents knew about that and covered that up. And then Hochfelder spent 2 years in jail before this transaction, after this transaction, not disclosed to my client. That's an equitable defense. That's one equitable defense.
No, but so what did your client say? Why would he have relied upon that? In fact, I don't think your client said at all that he relied on that representation in executing the guarantee, right?
Most respectfully, Your Honor, not correct.
Well, okay, tell me what he said.
Yes, Your Honor.
I wouldn't have executed the guarantee.
We have the affidavit of Robert Roche, and let's see what he says exactly.
Right. What does he say about why that would have been material to him executing the guarantee? Aside from saying, gee, if I knew that, but why would that have been material?
Because he was going into a partnership with a convicted felon. Because this person was telling him, you can trust me. I, Adam Hochfelder, and my group have invested $4 million, record page 317, for example, in other planned projects, and I want you to come along.
And there's no way he could have figured that out whether on his own.
Your
So
Honor.
he's just saying, I took the guy's word and I didn't do any of my own investigation. Guy tells me he's a good guy, and I believe him. And that's your basis for justifiable reliance?
That's my basis for saying that that's an equitable defense.
No. You have to at least plead facts because there's no doubt the guarantee is good. So you're saying I was fraudulently induced into executing it.
Yeah, I'm looking at Roche's affidavit. He doesn't say how there was a misrepresentation or how he might have justifiably relied on the misrepresentation into entering into the guarantee.
He invested in that, he writes, with the understanding that this guarantee would not be called by MCIP.
Is that statement, even if it was made, is that enforceable? Isn't that a promissory statement of something in the future? I mean, how would that be enforced?
I think most respectfully, it's an equitable defense. It's an equitable defense in the totality of these circumstances that give rise to a question as to whether this is an enforceable guarantee. And in fact, the guarantee says explicitly, I can invoke this sort of equitable defense.
But again, I'm not understanding. Why is that not merely a promisorial statement? Promissory statement. It's for the future, is it not?
It's in the past as well because they did not disclose who Adam Hochfelder was, his record, and his malfeasance. While they were negotiating this, they were preparing a complaint against Adam Hochfelder for stealing from Robert Roche and others similarly situated.
Just a question, because in the respondent's brief, it says that your client is a sophisticated businessman, attorney, chairman of the board of Cachet. Is that true?
Some of it is not, is outside the record, Your Honor. It says he contributed $3 million to charity. That's great. He's a good man. But good people are taken in also. And when you have a guarantee that
Well, it's not good or bad. It's whether he's sophisticated.
And a lawyer that knows.
Well, there's no record. The record does not say that he's a lawyer. In fact, he's not a practicing lawyer. He went to look. Well, it's not on the record as far as I see.
You have time. You have time on rebuttal.
Thank you.
Good afternoon, Justice Presiding, Weber, Associate Justices of the Court. My name is John Leventhal, and I am the attorney.
I just want you to tell me what you think about the justifiable reliance argument, okay?
So if you disregard Section 10 at Record 41, that there is a integration provision, this is the entire agreement, no further, let's say you disregard that.
Right. He's saying you fraudulently induced me into executing this guarantee.
So if you disregard the fact that there was a lot of consideration, we didn't get $1 million back. They didn't have to open nine Philip Chow restaurants, not only open them, but spend the money to operate them, that they had the use of my client's money for 27 months, and we forbeared from foreclosing. Now, if you talk what's fraudulent inducement, we give $3 million. We don't get anything back. you get a guarantee signed by Mr. Roche, and
And what do you say to his argument, counsel's argument, that if he knew what a bad guy your guy was, he never would have authorized the board?
Let's talk about what the representation was. Allegedly, Hochfelder says they're investing $4 million in another project. Therefore, you should sign the Second Amendment. You should sign the guarantee. Does that make really sense? Just because they're investing in
The
another
question, I guess,
project?
is whether
How is that
anyone could
relevant?
anyone could find that out, whether that was true or not.
Yeah, but
whether
that's
it's
not really relevant that they're
justifiably.
investing in another project for him to sign the guarantee. And the fraudulent inducement claim, we believe, is foreclosed by the rule that when the person claiming to have been defrauded has by his own specific disclaimer of reliance upon an oral representation himself has been guilty of misrepresenting. What did he misrepresent? That the partnership agreement supports this, that the director's resolution supports this, that I'm supporting it, that I stand behind the guarantee. What did he say? He's doing this because good faith. What does good faith mean? Good faith means, and to keep the peace, that you stand behind your agreements.
No, I don't even think that right. The guarantee was authorized by the board. The only issue is whether or not there was a statement that could have been justifiably relied upon. That's my question. So I keep going back to that because otherwise there's nothing.
I don't think you can rely on that.
Because of the integration clause?
Not only the integration clause, because there was consideration. He got a lot for it. What did we get? He didn't pay back.
But counsel, is there any statement in there that, yes, I justifiably relied on Hirschfeld's representation? Actually, really two aspects to it. One, with respect to the $4 million, and two, that the put option would not be exercised.
Well, the put option, as you said, that's speculative that it wouldn't be exercised. He signs an agreement that.
Is justifiable reliance alleged by?
I don't think that's reasonable, especially a person who is the chairman of the board, who is the majority shareholder, who is an attorney, who is a savvy business.
Well, your adversary said this is all outside of the record.
I'm not sure that is outside the record, Your Honor. I'm not sure that is outside the record. And if I may, the consideration completely set out earlier, I think, negates the fraudulent inducement. Look what they got. My client was fraudulently, was a fraud was committed on. Didn't get the $1 million back, didn't get the 9. So what happens? The First Amendment, give him his money back, open up these things. They didn't do that. They want everything and not to pay what they promised to pay. And I think this is really a fraud on my client, not a fraudulent induced perpetuated on Mr. Roach. Thank you very much.
Thank you.
Nice to see you.
A word about consideration.
Yes,
Past
the
consideration-
guarantee says that your client would materially benefit from entering into the ESA.
So let me respond. Yes, that's respondent's position, but it doesn't make sense because respondent is a person, Robert Roche. The shares and the redemption goes to Cachet Cayman. That's number one. So he could not give that's not consideration to Robert Roche. And in fact, this court has ruled that consideration has to be of a guarantee, has to be concurrent with the underlying transaction. What is the underlying transaction? Let's look at the guarantee. The guarantee provides that the underlying transaction is the ESA, which was executed 1 year before the guarantee. So you have a new document here, the guarantee, without a penny of consideration.
But doesn't the guarantee define the ESA as amended? And under that amendment, that is where Cachet has to make the money, the payment, correct?
Not exactly.
So I don't understand. It recites that the definition is this plus the amendment, and the amendment says I've got to pay. So where is this going?
But the this is what is not the addendum of the Second Amendment, which is 1 year later, a 3-pager. There are 50 pages of the underlying transaction.
Was Cachet required to pay under the Second Amendment?
Was Cachet required to pay under the Second Amendment? No, because we have the record.
Why would it
contains-
not, why do you say
Because
no?
we have because there are, we have affirmations, sworn statements of 3 members of the board that said that the Second Amendment was unauthorized and of no force and
But
effect.
under the agreement, they were not, I mean, this is your argument, but I mean, doesn't the agreement suggest that they were supposed to be paid under the Second Amendment?
No, the agreement was for the purchase of equity stake in Cache Cayman, not for the redemption. And we have the sworn affidavits of 3 board members said that this was a mistake. They were not authorized to create the put option provision.
Thank
This was
you, thank
illegal.
you all.
Thank you, Your Honor.
That was rebuttal. We didn't raise consideration before.
We'll take it under consideration. Thank you. People of the state of New York versus Trump.
Good afternoon. May it please the court. Christopher Keyes on behalf of all of the appellants except Ivanka Trump. The Attorney General in this case effectively asked this court to grant her unlimited authority to pursue Section 6312 relief. This represents an extraordinary departure from established application of 6312 and discards the settled, highly profitable business judgment of sophisticated banks and insurers which have never claimed any fraud.
Haven't we sort of already decided this issue? I mean, aren't we sort of relitigating issues that have been already decided?
Respectfully, Your Honor, I don't think so, because we now have an active case. And so I believe that prior to now, we were talking about an investigatory phase, and we were dealing with different pieces. And certainly the Attorney General's power is broad under 6312, but it's not unlimited. In the investigative context, it's a little bit broader than it would be when you have an active case. Now you have an active case. Now you have a case where there's really no public-facing, no outward-facing conduct of any kind. This is a transaction between two.
Wait. Are you saying that continuing corporate, alleged continuing corporate fraud is not something that the AG can remedy?
Your Honor, respectfully, that's, I think, where the disconnect is. There isn't fraud here.
Well, okay, that is the allegation. There's a trial. We'll figure it out whether there is or isn't.
No, let me be clear. None of the actual parties to the agreements are claiming fraud. So you have no mispayments, you have no late payments, you have $200 million in profits, you have no defaults.
So you're saying there's no damages to the state of New York if 2 parties agree to fraud?
Well, 2 parties haven't agreed to fraud. 2 parties have agreed to a transaction.
Let's assume that there is an allegation of fraud, which will or won't be proved at trial. And my question to you is, the fact that both parties acquiesce in the fraud, you're saying deprives the AG of the ability to prosecute it?
I don't think the Attorney General has a role when you have 2 parties engaged in sophisticated financial transactions.
So it's purely private. So your position essentially, it's a purely private contract. AG has nothing to do with it.
This is, yes, Your Honor. This
And
is
it doesn't
dominant.
hurt the tax revenue of the state of New York? It doesn't hurt the competition of the state of New York? It doesn't hurt the banks that aren't privy to that alleged fraud in the state of New York?
I think, respectfully, Your Honor, I think the greater risk to the fiscal good of the people of New York and to the business community and to the Attorney General cites the New York status as the preeminent financial nerve center. I think the greater risk is allowing a government official to come along 5 or 6 or 7 or 8 or 10 years later and interject itself into successfully consummated private transactions where the parties haven't done anything.
Even if the successfully consummated transaction are based on fraud?
But that, again, that's where...
Again, we're going to see a trial. We're just assuming, but assume for the sake of the question that the transactions are based on fraud. You are saying to us that the AG has no ability to redress that situation.
I am saying, Your Honor, to be clear, that there isn't, this record just so far doesn't even demonstrate fraud.
You haven't argued, right? We're not arguing, yes, on this appeal, you're not arguing failure to state a claim, right?
No, no, Your Honor.
So we assume for the purposes of this motion that the fraud is adequately alleged. But you keep saying because the two parties to the fraud, alleged fraud, aren't complaining of it, therefore the AG can't address it. That is the argument that I am having difficulty accepting.
And I understand that, and maybe I'm not articulating it clearly. What I'm saying is if you look at the gravamen of the complaint, if you look at the substance of it, not the nomenclature. The nomenclature is, oh, this is fraud, this is fraud. But if you look at the allegation of the complaint, if you look at what's attached to the complaint, what you will see is there are established, there's these complicated agreements. They have established standards of conduct. The any default or breach required material departures.
Again, that you're not arguing failure to state a claim.
But I am arguing, Your Honor, that there isn't a fraud here that is within the capability of the Attorney General to address, and it's because
which is almost the same as arguing that there's a failure to state a claim, which you are not doing.
It's slightly different, Your Honor, in this way. It's all about who gets to decide whether these valuation determinations are correct. In the first instance, that has to be the parties.
But doesn't the state, doesn't the AG have an interest to regulate business within its borders? And isn't that what's occurring here, counsel?
The Attorney General has an interest, and this is what the Attorney General argues.
Because essentially what you're saying is this is completely private, no one's complaining about that, why is the AG looking into this?
I mean, effectively, yes, because there isn't really a role. Every 6312 case, every one that's cited by the Attorney General involves public-facing, outward-facing conduct of some kind, some implication. This doesn't affect anyone but these two parties in the first instance.
How do we know that at this point until there's been a full trial? I mean, how has that been established?
Because it's just like Domino's and Exxon. The Attorney General says that Domino's and Exxon don't apply because those are summary judgment or trial cases. But we already have the record here. We already know what's going to happen because it's in the record. That's the difference between those cases. We don't have to wait for a trial because we know that the parties to the transaction, the bank whose responsibility it was to make the determination in the first instance.
Okay, so what happens when the bank fails because of all the fraud, and then the people of the state of New York have to pick up the cost of that? It is not if it's proved, again, we are only on a pre-answer motion to dismiss, you may prove at trial that none of this was fraudulent. But what I am saying to you is I have a hard time accepting that there is no compensable damage to the state by two parties participating in fraud. That is the problem. Not because I today can't say every New Yorker is out $1.98. That's not really the standard.
It's not the standard, but the standard is there must be some public impact of some kind. And so your hypothetical, respectfully, Your Honor, presumes that there was a default. That's a completely different case. If the party whose responsibility it was to make these valuation determinations in the first place, the Attorney General has 48 references to materiality, 25 references to, I see my time's up, may I finish my answer?
Yeah, please.
Thank you. 25 references to the contract documents. This is all about the contract documents. Their entire case, just on the record before you, not when we get to trial, rises or falls on what happened between these two parties. And in the first instance, that is for the bank to make that determination. The Attorney General has no role. If we establish honest marketplace as the standard, then there is no standard because that would apply to any and every transaction. And you're opening the door then to the revisitation of every single private transaction that goes on in this city and in this state. And I would suggest respectfully that's a very dangerous standard. Thank you.
Good afternoon. May it please the court. Bennett Moskowitz for Ivanka Trump. The Attorney General waited too long to sue Ivanka Trump. That's issue number 1 of 2 that I'd like to...
So what is your position as to the last possible action or inaction that could apply to Ms. Trump?
Absolutely. It's when the last of the transactions at issue that she was allegedly involved with closed. We have lots of case law, which is 2014. So even if the 6-year statute of limitations applies, they were too late.
How about the 2016 disbursement?
I'm happy to talk about the disbursement.
Would that be a continuing wrong? Would that renew the
It would not be a continuing wrong.
Why?
It's not a wrong. It's an effect from the allegedly fraudulently induced transaction from years earlier. We have case law on that too that says effectively, for example, a case involving an insurance policy that was fraudulently induced. Paying the premiums thereafter is the effect of the fraud. The draw, getting the money that was already secured and available.
So it's not a new wrong.
It's not a new wrong. It's an effect of the wrong. That's not enough. So they're too late here. The continuing wrong doesn't work, and nor does it work for them just to sit back and go, well, we allege there's this broad conspiracy, to which we say, yeah, but what do you say Ivanka Trump did in that conspiracy within the statute of limitations? They say nothing. So what do for the first time on this appeal, because they know they have an issue here? They say, well, aha, we have this tolling agreement we entered into with the Trump organization. Respectfully, I'm a little surprised they made that argument. Number one, because they didn't make it below, so they waived it.
Did your client sign that tolling
No,
agreement?
he had been gone from the company for many years.
When
and they're
did,
saying
when did she resign from the Trump organization?
January 2017. This is many years later that they say the Trump organization. By the way, this is in the record too. At the special proceeding, they argued that Donald Trump, the former president, wasn't bound by the tolling agreement. How could you now come to this court and say, well, but Ivanka Trump, who wasn't employed then and hadn't been for years, is part of it?
Was there any allegation or indication that the Trump organization signed or entered into that tolling agreement on behalf of Ms. Trump?
No, the opposite. It's totally lacking. If anything, I recall the record suggests the opposite, and she didn't have anything to do with it. I could make that representation.
Counsel, would the tolling agreements or the executive orders have any effect?
The executive order only has effect if you go back to the 3-year statute of limitations arguments. Here, the way my position is, no matter how you slice it, the Attorney General was too late. So I'm presenting the court. So to answer your question, no, it wouldn't have effect on what I'm presenting to the court, which is that even if you give the most generous 6-year statute of limitations and we still maintain that 3 years is proper, they still were too late. The draw request isn't enough. And then they have this other allegation that's not even remotely close to the draw request, which is itself not enough, that says that she at some point had some conversation with someone about a potential refinancing. Never happened. They don't say anything she said was fraudulent. That's not enough either. Thank you.
Counsel, what about the annual statements and the certifications that, if I just want to finish my question, thank you, that, they still were true, accurate with respect to both of the loans?
Yeah, they weren't her certifications.
Okay.
Thank you.
Thank you.
May it please the court, Judith Vale for the New York Attorney General's office.
Can we address Ms. Trump's arguments first?
Sure, absolutely. I mean, there's a fundamental false premise underlying her arguments, which is the idea that these are one-and-done transactions that closed a long time ago and that's it. That's just not what the complaint alleges at all, and we are here on a motion to dismiss where the facts need to be taken
What
as true.
subsequent actions are you talking about after the last one?
Well, there are 5 broad categories of allegations that show that altogether that show that Ivanka Trump helped set up some of the core transactions through which the fraud was perpetrated, not just at the beginning, but also going forward every single year when the statements were resubmitted and recertified.
No. That's the question. That is the quintessential effects of an earlier breach.
I don't think that's right, Your Honor.
Okay, let's assume that I think that that's a quintessential. What else? What specific actions do you have in the limitations period other than paying out some of the...
Well, the disbursement request is a separate wrong. It is not a lingering effect, and let me explain why.
I'm asking you, other than that, what do you have during the limitations period?
We also have, if you look at the limitations period of 6 years plus the COVID tolling, which we think the court has already decided both of those issues, during that time, you do have Mazars compiling the 2015 statement, and that statement is getting submitted to Deutsche Bank, and Deutsche Bank is doing a review. And during that period, Ivanka Trump is a executive vice president of the company who set up the transactions that are now, I do want to emphasize that the statements,
But that's
they are
all, that's
new
all related
statements.
to the prior alleged fraud then. And
But
that's,
she also, well, they are new statements for new periods, but even if the court
I'm
doesn't
just,
agree with
right,
that,
that,
even if the
right.
court doesn't agree
What's
with that,
new? That's what we're trying to look at. What's new in the 6-year period?
the disbursement request is new because it
An
is
act that is
conditioned on
unconnected to something outside the 6-year period. What is new in the 6-year period that is unconnected to anything outside the 6-year period?
If I could just finish the thought on the disbursement request, but Your Honor, then I will move to another example. Another example would be that it's alleged that Ivanka Trump was personally involved with some of the assets that were misvalued on the statements. And for example, the penthouse apartment was her apartment, which she had the option to buy at 3 times less than the value that was listed on the statements. We are here on a motion to dismiss, and it is reasonable to have a plausible inference that she participated in and knew about the fraud when it was her own
Do
apartment.
you have to plead fraud with particularity?
We don't think so because this is a 6312 case. But even if we did, that's fine. I don't think the court has to resolve that issue here. Scienter and actual reliance are not required for 6312. And so what we need to plead, if particularity is required, is that she participated or knew about the fraud during the period.
So
And
what facts have you pled to show that?
she set up the transactions, and I do want to emphasize that the statements are not lingering effects. The lingering effects cases are fees that are getting charged. These are the loan documents required as a condition of the loan that they would submit new certifications every year. It's a new fiscal period with new
but it's
valuations.
all related to the alleged earlier fraud. I mean, that's what it seems to me is what you're alleging.
But they were also
What you're
using the
just saying
statements.
is your argument is that it's just a new wrong, and I'm not sure.
Well, there's two ways to look at it. If it's we think it's plausibly alleged that every time a fraudulent statement was submitted to Deutsche Bank, that is a new wrong that accrued.
So every 2
And that
years,
did-
so you're stating that every 2 years they were required to submit additional documents?
Every single year.
Every single year. So you're stating that every single year there's a new fraud or
That would be one way to look at it, yes, is that every single year when a new statement is submitted with new valuations, old deceptions are being used in new ways. Sometimes new deceptions are being used. If you look at the chart in the record at 1395 to 96, you can see a snapshot of the different asset categories and deceptions. And there is a statement. The 2015 statement is submitted to Deutsche Bank during even just the minimum 6-year statute of limitations period once you add the COVID tolling. And then the disbursement request is also another wrong because it is conditioned on all of the prior statements being true and accurate as of the time of the disbursement request, not as of the time in the past, but as of the time of the disbursement request, as if it has the same effect on the day of the disbursement request. And that is why that is also a new wrong. And we think this fits either within it's a new wrong that is accruing each year, including squarely within the statute of limitations period.
I'm sorry to interrupt you, but can you really address the standing issue because I see you're down to a couple minutes.
Yes. Just to finish one thought, I would say the continuing wrong doctrine also applies to Ivanka Trump. The standing and capacity arguments just fundamentally misconceive what 6312 is about and what this case is about. This is not about a purely private contract dispute.
Well, how is it not purely private?
Because the legislature has chosen to make the Attorney General's office the civil enforcer for any.
So here the argument is that look, this is a completely private contract. No party to the contract is complaining or alleging any kind of events of default. Why is the AG here in the middle of this?
Because the legislature has written a broad statute that says that any person who engages in any repeated fraud or illegality in the conduct of business in New York is subject to 6312. The Attorney General is here to protect.
Regardless of whether or not there's any public harm?
Well, we think the legislature has decided that there is public harm when there is repeated fraud and illegality.
What's the public harm here?
Here it is the integrity and honesty of the markets are affected when people can't rely on people telling the truth when they certify that they're telling the truth. And it does ultimately harm other participants.
The reliance is by the bank, and apparently the bank did not have an issue in terms of whether they were telling the truth or not.
Well, actual reliance is not required for 6312, especially because we are here seeking disgorgement. This is not a claim seeking damages that would go to an individual victim.
Okay, so actual reliance is not required. What type of reliance would be required?
There isn't reliance required, although there's actually plenty of allegations, even if it was required, that Deutsche Bank did rely on the misrepresentations. But I do want to also emphasize that other participants in the markets are harmed by fraud.
No, wait. But you can't possibly mean that any time anyone alleges a fraud in a commercial transaction and a complaint, that the AG can move to intervene under the statute. Is that what you're saying?
Well, I'm not saying that we would intervene if there was a private lawsuit. I'm saying that if there is repeated fraud or illegality in the conduct of business in New York, then the Attorney General has discretion whether or not to bring a claim. Now, to prove an actual damages claim, you would have to prove that there was a direct financial loss to an individual. But this court and the Court of Appeals have already made clear that disgorgement does not require a direct loss to the public. And I do just want to finish the thought about how participants in the markets are harmed. These transactions don't take place in a vacuum. There are real estate markets, there are insurance markets, there are banking markets, and the honest participants ultimately end up subsidizing the cost when there is fraud and dishonesty because they don't get the better loan terms that were gained with fraud. They suffer the consequences if there are hits to the market.
Thank you.
Thank you.
Thank you, Honors. Just briefly, I think what you've heard here really facilitates our argument, and that is the Attorney General has still not articulated for this court what the limits are of the authority under 6312. There's no articulation. Their argument is what you just heard, which is the legislature has authorized it, and so that's it. That's the beginning and the end of the analysis. That's tautological. It's circular reasoning.
Isn't that really essentially a defense you could raise at trial, and ultimately that's something that we would consider on appeal, depending on what the trial court does with it?
Respectfully, I don't think so, Your Honor, because there has to be this threshold. There has to be. The Attorney General's position is writing all of you out of the picture. It's basically saying the legislature's decided this, we have the discretion, none of you in this courtroom respectfully have anything to do with this analysis, and I think that is just inconsistent with the application of 6312. I also think that the danger to the marketplace that I was referencing is borne out by what counsel just said. Oh, we don't have to prove reliance, we don't have to prove scienter. We can run around and say fraud, 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 but we don't actually have to prove fraud. We just have to allege it. And in a situation like this where you have sophisticated parties, even by the Attorney General's math.
But this is a motion to dismiss. It's a motion to dismiss, in effect, correct?
It is a motion to dismiss, Your Honor.
So on summary judgment, I think I would be more receptive to the argument you're making, but we're really at a early stage of this proceeding.
I respectfully would disagree with that, Your Honor, and here's why. Because we already have this in the record. You already have in the record what you had in Exxon and Domino's after a trial, which
Well,
is...
you know, you made that statement before, and I was going to say, you said we already know, but I'm curious as to how do we already know these things?
Because there's no allegation in the complaint. We're looking at the four corners of the complaint. There's no allegation that Deutsche
Don't
Bank...
we need some type of discovery, some type of fleshing out of the complaint? A motion for summary judgment?
They had 3 years to investigate, Your Honor, and certainly if there was any ability to allege that Deutsche Bank or Zurich or any of these entities had any problem with any of these transactions, you would expect it to be there. I want to speak briefly, just touch on one thing briefly about revival and retroactivity. I realize that some of the panel members, so respectfully, were on the Allen, Jewell, and Cohen decisions. But the Regina decision, the Regina Metro decision out of the Court of Appeals, separates the retroactivity and revival analysis very clearly. These are quotes. Revival is an extreme exercise of legislative power, requires an even clearer expression of legislative intent. The statute's text must unequivocally convey the aim of reviving claims, and there's no revival absent unambiguous statement of legislative intent. So respectfully, the Allen, Jewell, and Cohen decisions don't distinguish between retroactivity and revival. They appear to just move past those issues. And so whether or not the language in the adoption of 213.9 is sufficient for retroactivity purposes, it's certainly our position that it's not for revival purposes. And so I would ask that this court take a careful look at that again, looking closely at the language. And this does matter because if you look at August 2019 as the adoption of Section 213.9, then you look back either 3 years or 6 years. So you're either looking at August of 2016 is the cutoff, which we advocate for in our briefs, or August of 2013. But either way, the only language that's in 213.9's adoption is shall take effect immediately. That's simply respectfully, again, I know Your Honors, some of Your Honors were on these other decisions, but respectfully, that doesn't satisfy the standard under Regina. And so there's a cutoff. We think it should be 3 years because the adoption of Section 213.9 was to fix, according to the legislature, what the Court of Appeals had done in Credit Suisse. In Credit Suisse, the Court of Appeals said the statute of limitations is 3 years, period, full stop. So then that would be the look-back period for revival purposes. As of August 2019, that would be the look-back period. Because if it were 6 years, there would be no reason for the legislature to have acted at all.
Thank you.
Thank you, Your
all.
Honors.
Thanks, Chief.
Friends of Elizabeth Street versus the City of New York. Elizabeth Street versus the City of New York.
You, Ms. Fellows? Yes. I need to.
Good afternoon. May it please the court. Mackenzie Fellow for the City Appellants. This court should reverse because the city gave a hard look at the open space issue and came to a rational decision. There is a small reduction in open space associated with this project, but that small reduction comes with a substantial increase in public access to the open space that will be created with the new project. There will be longer hours every single day of the year forever. And maybe rational people could disagree about which one is better, a bigger space that's open for fewer hours and could be closed at any time, or a smaller space that is open to the public forever. But it is certainly rational for the city to determine that the difference is not significant. The reduction here is 2.24%. It's solidly within the range that the technical manual gives the judgment of the city to decide what is significant or not. And this court has held many times that compliance with the technical manual is evidence of rationality. If the court has no questions, I'll save for rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Benjamin Estes for Appellant Riseboro Community Partnership, and I'm also arguing today on behalf of Habitat for Humanity. Your Honors, it is undisputed that the petitioners have not made any allegations of wrongdoing against Riseboro and Habitat for Humanity, and they have not challenged our position on this appeal. So in view of that, barring any questions, we're happy to rest on our papers and respectfully request dismissal with respect to Riseboro and Habitat.
Thank you.
Thank you.
May it please the court, my name is Norman Siegel. I represent the respondents in the Elizabeth Street. This case involves the attempt by the city to destroy Elizabeth Street Garden, a cherished community garden, 20,000 square feet, in an area that has a paucity of open space.
So the question is whether or not there was a hard look. And you heard what the city had to say. Why do you believe that there was no hard look in this?
There's no hard look because the conclusion that the judge, in a very well-reasoned opinion, said is that the EIS, the negative declaration, not an EIS, huge difference. EIS, they sound the same, but EIS is a very more in-depth, talks about alternatives. EIS doesn't have to do that. EIS, the people have opportunities to have hearings. In EAS, we find out on November of 2018 that behind closed doors, the HPD and the City of New York decide that there is no problem with open space. There's 20,235 square feet. This plan, Haven Green, is going to reduce it to 6,700. And even if you take the argument that they're making that the tunnel, which is not open to the sky, which is what the requirement is, came in, you would have 58% reduction of the open space. With the 6,700, which is what we argue, you're talking two-thirds.
Isn't counsel correct that the space now will be open for longer hours, et cetera, so that balances that, doesn't it?
It's such a bogus argument, Your Honor. And it's bogus because if that's what their concern is, put it in the garden lease right now. make it a specific requirement. They didn't argue that in the lower court. They're arguing it now. I don't know if that's even appropriate, but it's bogus and gets us angry because all you have to do is put it in the lease, and that's the requirement. You're talking about on the standard with regard to CEQA and the city training manual, which gives you guidelines in the city. What you're supposed to do is take a look at the training manual, and there's a quantitative analysis. If it turns out that the increase of the new project, you have no problem. But when there's a decrease, and a significant decrease, because the language says that even if it's 1% reduction in areas that have, what I started with, a paucity of open space.
But Washington Square Park, as I understand it, is right on the edge. It's right on the edge. I know it's outside the study area, but isn't that something that we could look to?
They call it a designated park in their argument. The training manual doesn't talk about designation parks. It talks about regional parks. Washington Square Park and Tompkins Square Park, which they threw in on the appeal, not in the lower court, is not a regional park. So when the judge below in her decision says they're not following the guidelines, that is one of the standards on Article 78, a violation of lawful procedure, an error of law. So in the context, and arbitrary and capricious. When you talk about what happens at the Elizabeth Street Garden, it's sui generis, it's unique. People come, they come for workshops, they come for poetry, for music, and then there's groups like the YMCA in Chinatown. They have big events. The New York Public Library has big events, and they get well-intended. The annual in 2019, I could go on today, but it's not in the record. In 2019, the annual harvest event had over 2,000 people during the course of the day. If you go ahead with this Haven Green project down to 6,700, you won't be able to have these kinds of events, and that's what CEQA looks about. And again, it's an EAS, which is done behind closed doors, and EIS, that's what we wanted to do. When the developers start to argue about there's going to be a chill on developers, the answer is this is not about affordable housing for seniors. That is
Well,
not
isn't that exactly what's going to be put in? Isn't that what this is for affordable houses for seniors?
You have to do affordable housing for seniors. And my
Right? Isn't
clients-
that what's going to affect that space? The affordable houses for seniors, housing for seniors, correct? It's a city-owned space, and they want to use it for affordable housing for seniors,
In a
right?
court of law, my answer to the 5 of you is it has to be done according to the law.
Well, so
It's
that's
not
what I'm
being-
trying to figure out. What is it that, I mean, you always have to make hard choices, right? We agree.
You have to make what?
You always have to make hard choices, right? There's always going to be hard choices. I just want you to tell me, what specifically are you saying that the city didn't do? They took a look. I mean, we went through each part of the study. What are you saying they didn't do? I understand that you are unhappy with the choice they made.
No, it's not unhappiness,
But,
sir.
okay,
Excuse
but
me.
what I'm trying to figure out is what is it specifically that you're saying they didn't do that they were required to do?
They didn't follow the law.
In what way?
When you do the quantitative analysis and you get a minus 2.24, which means 14,000 square feet are now going to disappear in a neighborhood that's very dense. You go to the qualitative analysis, you take a look at the other open spaces.
But you're saying you disagree with their conclusion, but not that they didn't do it. They did it, right?
They didn't do it properly according to the guidelines in the training manual that the city has.
What
And the judge
guideline are
caught
you
them on
saying?
that.
What guideline are you saying they didn't follow?
Very simply, what you're supposed to do is take a look at what the other spaces are.
And you're saying they didn't take a look at what the other spaces
Look
are?
at the other spaces, but then you have to see what are the purposes and the uses, the functions that
Did they not do that?
They did not, for example, articulate in the EAS the specific events that occur. All they said was general, that it was a sculptural garden, commercial, and it in fact had some public events. It didn't talk about some of the events that I talked about, because when you—
Is that required?
Excuse me?
Is that a requirement?
Yes.
Under the
You have to take a look at what the function—
Yes, but
Yes.
clearly they took at it, but you're saying they didn't list all the events. Is that a
Exactly.
requirement in the guidelines?
Yes.
You have to list all of the events?
You can't be superficial when you're dealing with to see whether the qualitative factors mitigate the reduction. If they had a new project that had, 25,000 new open space, we wouldn't even be here. But what they have is a project that this is not, when I say it's not about affordable housing, don't get me wrong. We're not a NIMBY group. What we're saying is create the affordable housing, but you have to follow the law. If you can't follow the law, then you got to redo it. They could have easily done an EIS 4 years ago, but instead, behind and closed doors, they go ahead and do an EAS. We get that information. We go to the ULURP hearings. They say we didn't perhaps raise these issues. You take a look at the record, and in April 10th, 2019, they recognized 2 of the lawyers representing the garden got up and talked about the zoning problem.
Is there any requirement or statement that they have to do a EAS versus a EIS?
They make a decision up front, and if you're a type 1 action, which this is,
yes,
the presumption is you get an EIS.
An EIS, but
right.
Here we don't have an EIS, right?
They did an EAS.
Okay.
That was their fatal flaw from day one.
So your argument is also that they should have done an EAS as opposed to EIS.
Just the opposite.
They should have done
an EIS, an environment EIS, as opposed to an assessment. They had to do an investigation. And finally, on the zoning, what's so important.
And the manual also dictates what type of assessment they're supposed to do. Is that correct? The manual also dictates
qualitative analysis. Yes.
Right. Okay.
Spells it out. And on page 12 or 18 of the judge's decision, she lays it out in a paragraph. She did a really good job. Most important, she followed the standard that when judicial review, you have to be limited. You can't say, I desire something else. I'd like something else. What you have to do is base it on the fact that legally they didn't comply with the law.
So
on the zoning, let me just finish on
well, let me finish. So can we conclude, right, that if they had laid out all of the various functions that took place on the garden, et cetera, that would have led to a different conclusion in terms of whether there was ample open space or not?
You opened the door for me, thank you. If you did the environmental EIS, you never would have got to that, because then you could have analyzed what they were saying with regard to those functions. And most important, the rule of law, the zoning, and we do have jurisdiction for this. The zoning, the developers, when they filled out the one of the forms on the ULURP, they checked the box that it was consistent with the zoning.
They checked no for a resulting change in land use different from surrounding land uses.
Thank you. And that's absolutely not correct. And then on the EAS, they did the same thing. They therefore are arguing to HPD. HPD has a responsibility to people of the city of New York to look at those forms. Why ask those questions? The answer to those questions was no. If you had an EIS, they would have had to go into depth about the zoning issue. And part of our argument is not just CEQA. Our argument was that it was an error of law. You don't have to do it under CEQA. We also argued that under ULURP, and we testified at those hearings, that in fact, it wasn't in compliance. They make the argument that no one ever raised it. It's in the record, thank God for the record. So the zoning, going back to the rule of law, I believe in the rule of law. The rule of law says that in fact, if you fill out a form and one of the developers swears to it and they check the box and the box says it's consistent with the zoning and it's not, how can you let that go on?
Okay,
let's hear. That's an error of law.
Let's hear again from the city. Thank you.
Thank you. First of all, the technical manual does not require the assessment to set out that they have yoga classes on Thursday or whatever.
So why an EAS as opposed to EIS?
The SECRA expressly allows for an EAS to be done instead, and if the EAS is done and then the city issues a negative declaration, no EIS is required. Many of the land use cases that this court hears involved EASs and not EISs.
And the zoning, so it is clear that they checked off no in response to the question for a resulting change in land use different from surrounding land uses. And your adversary states that that is incorrect, that that's not true.
Yes,
how do we address that?
They claim that a zoning amendment is required. No zoning amendment has been sought. No HPD is not involved with zoning. The people who will decide zoning is DOB when the developers go and ask for a permit. And until that happens, this issue is unripe. And
And then also, you stated previously that the garden would be open for longer hours.
Yes.
It's not in the lease. Why is it not in the lease?
well, there's a month-to-month lease that has been going on with the private lessee who owns the property next door, or it's a corporation actually, for I think 30 years or something. And it's never required the lessee to operate it as a garden. He's doing it of his own volition. The point is, though, that at this point, this is a city-owned lot. It's not a park. We're in a massive affordable housing crisis. The city has determined that affordable housing is going to be on this lot.
So at some point in time, is this going to be included in the lease, that it's going to be operating for longer hours?
Well, the lease is going to be terminated because it's a month-to-month lease. It can be terminated at any time by either party. And hopefully we win this appeal and we can go forward with this project. But if not, this is still city property, and we can ultimately we can decide to have a different project there if this one doesn't work out for some reason.
But that would require another look
It
and
may
notice to the members of the community, right?
Exactly. If we do not prevail on this appeal, we have options available. We could do the EIS, or we could start from scratch with something else. But either way, this is city-owned property. The city has determined that affordable housing
So
needs
where
to
are
be
the
here.
city? You're saying it's a city-owned property, so.
Yes, yes. And
So why in the report are we including Washington Square Park? Why are we including Washington Square Park? It's not really on the border, is it?
it's just outside the study area, and the technical manual on page 714 of the technical manual expressly says that the city can consider other factors, including the presence of other parks outside the study area.
Even if those parks are not used for the same, are not generally used for the same purposes as this particular park, this garden?
Yes. The point is that the city, that the people of the current open spaces in the area will not be overburdened by the reduction of space here. And as I said before, the law does not require the city to just say they have these classes on this day, they have these fundraisers on this day. It requires the city to look at active uses and passive uses, and that is all set out very clearly in the open space chapter of the environmental.
But aren't those active uses?
The garden here is a mostly passive site. It's not a track or grassy fields that people are running on. It's generally a passive use, and those uses are set out in the EAS. And the city was not required to go in more detail about the uses of the area.
Thank you. Thank you all.
Thank you.
Well,
I don't believe you
I
had
need to
any-
have some time for the cross
He
appeal.
did not request to reply.
You did not, no, you did not.
I requested 15 minutes, and you turned me down to 6 when I said 13. We have cross appeal when you're talking
I
about.
think you have, you don't have any time on reply, no?
Can I ask for 2 minutes?
I'll give you 2 minutes.
Thank you, Your Honor. With regard to the issues, with regard to the cross appeal, which is all part of this as well, for example, CEQA requires the city to take a look at its public policies. So we have climate change. They don't take a look at green infrastructure. They don't take a look at the executive order that the mayor did, Executive 26.
Are they required to take a look at climate change or anything of that nature under
They say
rules?
it's amorphous. But the point is that when you take a look at the city's commitment to green infrastructure, to trees, to combine sewer overflows, they went into a consent decree with the state to make sure that we would have impervious, so that when the rain comes, the grass can absorb it. The trees are crucial, so that when the rain comes, we'll absorb it, so we don't have the sewer overflows. They didn't even look at it at the EAS. They ignored the whole thing. With regard to climate change, rising heat, open spaces that are green with trees reduce the climate change challenges that we face. All we're saying is that they should have addressed this, because that's part of the CEQA aspect where you have to address any potential, it says, may have an adverse effect on the environment. The neighborhood challenge, I'll give you one thing. One of the women, Poppy King, says, and I write, why tear down a space that is already operating as a heart and soul for a neighborhood? The community has a jewel in its midst, that will forever serve the community in a way that nothing could replace or attract as Little Bay Street Garden. The zoning says that all the buildings, the walls on the building have to be adjacent to the street. When they built this thing, they have the building over here on Elizabeth Street, but then they have a setback of more than 60 feet from Mott Street. It's totally illegal because the whole reason of a special Little Italy district is they wanted all the building walls to be adjacent to the street. No setbacks, no front yards, and therefore this project has exactly that.
So presumably, if that becomes an issue, when the developer seeks a building permit from DOB, can't you raise it at that point?
You should raise it now because SEQR, if they did the EIS, would have had them address that issue. Why do you have the forms asking the question that Judge Weber raised? Why do you have these forms for the environment assessment statement and for the ULURP process? They ask the questions about zoning. They say, we can't raise it now. It makes no sense. We shouldn't have to wait to the Department of Building. If they talk about the negative effect for developers, that'll create it even more. What they did from the very beginning, the fatal mistake, was not using an environmental impact statement. And Justice James caught them on that, and therefore in her decision says, you need to remand it back for an EIS. What we ask this court to do, at a minimum, is affirm, but second, take a look at the cross-appeal issues, because they're very significant and they violate the law. Thank you all very much, and thank you for the extra minutes.
Have to give it a couple minutes. All the interesting things.
Okay. How do you know this? This is the case to be called now. You guys just stand and sit. How do you know this is the case we're going to call?
Sorry for assuming, Your Honor.
I'm just joking. It's okay. I hope you're on People v. David Coleman.
Yes, I am, Your Honor.
Okay, good. Proceed.
Good afternoon. My name is John Palmer, appearing on behalf of David Coleman. The sentencing court abused its discretion by summarily denying Mr. Coleman's plea withdrawal motion without conducting any meaningful inquiry. Accordingly, we ask this court to hold Mr. Coleman's appeal in abeyance and remit it to the lower court for proper consideration of Mr. Coleman's plea withdrawal motion. Mr. Coleman moved to withdraw his plea, alleging, among other things, that he was forced to go pro se, that he was not fully informed of the consequences of his plea, and that he did not fully understand the instructions he did receive.
So the record was a little confused. Sorry, go ahead.
It's fine. Go ahead.
No, you're on. Go ahead.
I was just going to point to the transcript, which of the actual allocution, and I'm just wondering, at some point, the court engages in this long summary, actually quite descriptive as to what it means to go pro se and what it doesn't mean to go pro se. He goes over his education. He goes over the consequences, the fact that he would be treated the same as any other attorney. What else was necessary?
Well, Your Honor, the pro se colloquy itself is not the issue here. It is more that Mr. Coleman felt that he was forced to go pro se, in that
How was he forced to go pro se? He asked to go pro se. Oh, because the court wouldn't appoint a new attorney?
Uh, yes, Your Honor, in that Mr. Coleman did not provide or demonstrate a definitive commitment to self-representation. We live in a universe of the law where a person saying, I'd love to go pro se, is not always enough for that person to go pro se.
And then I always find it interesting because if the court had, if you denied the application to go pro se, then on appeal they said, you should have granted my application to go pro se. If you grant the application to go pro se, then they come back and say, you never should have granted my application to go pro se. It's like you're in a lose-lose situation. But in this case, he asked to go pro se. The court advised him as to the consequences of going pro se. As my colleague stated, the court went through this long colloquy as to whether or not the defendant had the ability in terms of legal acumen, et cetera, to go pro se. The court advised the defendant as to the role of the attorney Abelafia in terms of assisting him. So I'm not really clear why there would not be, why you're arguing that, you know, he did not wish to go pro se, or that he was forced to go pro se.
Well, Your Honor, there must be an unequivocal request, and throughout the proceedings, going all the way back to when he was first allowed to go pro se, he in that proceeding in January 2017 expressed interest in hybrid representation when asked
So
if he wanted to
counsel,
go pro se.
that was, so the second lawyer that was the second lawyer he was unhappy with, correct?
It was the second lawyer he was unhappy
So
with.
he was now asking for a third lawyer, which the court said no, and that's when he said, I want to go pro se, correct?
Correct, Your Honor.
All right, so what is the problem with that?
As an alternative to a request to go pro se is not unequivocal, and it's simply an alternative means to rid oneself of an attorney that they do not like. Or
Is it your position that defendants can continue to just keep requesting attorneys when they're unhappy with them and the court continuously has to grant that? Because I don't think that's what the law is.
Of course not, Your Honor. You do not have the right to successive attorneys. And this court does not have to find that there was good cause for the court to replace Mr. Abelafia. But it is clear from the record, the court can see, though, that Mr. Coleman's preference was to have a different attorney, not to go pro se.
But he didn't even make out the basis for a new attorney. All he stated basically was that his attorney had, quote unquote, thrown him under the bus. He didn't really talk about why there would be a need for another attorney. I mean, there was nothing about a breakdown in communication, about, you know, the attorney not representing his needs, et cetera. It was kind of just that one statement, and he never really stated anything more.
Well, Your Honor, throughout the proceedings, again, the court does not have to find that there was good cause to replace the attorney.
You do.
Our argument is simply that.
I disagree. I think there has to be, there has to be some finding as to why there should be an appointment of a new attorney. But we'll discuss that on rebuttal.
Thank you, Your Honor.
Your Honors, and may it please the court, Anna Notchik for the people. The court below was under no duty to appoint defendant a third attorney where his complaints about counsel were vague and conclusory. Further, defendant unequivocally expressed his desire to go pro se, both at the January 30th.
Counsel, what should we make of this statement that the defendant said? If it's possible that you decide I'm not qualified to represent myself, is it possible to get another lawyer then? Is there maybe some way that that could not be an equivocal statement?
Well, that statement clearly shows that defendant's preference was for self-representation, and even if it wasn't, as this court has acknowledged, a request to go pro se is not ipso facto equivocal simply because it is made in the alternative. And we would also argue that even if the court violated defendant's rights, it cannot be said that it affected the outcome of the case because defendant ultimately accepted the same plea that was offered to him when Abelafia was his attorney. Further, Justice Fitzgerald, who had, of course, presided over the plea proceeding, providently exercised his discretion in denying defendant's plea withdrawal motion. If there are no further questions, we ask that you affirm. Thank you.
Just two quick points, Your Honors, as to what my adversary just said about how even if the court shouldn't have allowed Mr. Coleman to go pro se, it did not affect the outcome. This is not a case where Mr. Coleman was able to go pro se at a suppression hearing, and it turned out when he went to trial with an attorney that that problem was harmless. Here, the harm in going pro se or being allowed to go pro se when you should not have is that you could have gone to trial,
Why shouldn't he have been allowed to go pro se? If he asks to go pro se, if the court says, I'm not going to give you a third attorney, this is your attorney because you haven't expressed a reason why I should discharge him, and then your client says, well, in that case, I'm going pro se, why shouldn't the court have, and the court does that incredibly detailed allocution, I guess, why shouldn't he have allowed that?
because Mr. Coleman did not demonstrate a definitive commitment to self-representation. He, throughout the proceedings, referred to the possibility of having another attorney.
But didn't he have the choice? Didn't the judge say to him, your lawyer's right here the entire time? So he didn't he have the choice to have the lawyer represent him? And he chose not to, right?
He chose not to.
Right. So I'm trying to figure out what's wrong with that?
It's that, Your Honor, very simply, it is that he did not demonstrate a definitive commitment to self-representation. Throughout the proceedings from the very beginning, he mentioned the possibility of having a new attorney.
But again, what about the court questioning him concerning his ability to go pro se? What about that discussion with the defendant? How do we view that then?
That the court did do a pro se colloquy. Right. And the issue is not so much with the colloquy, it's that Mr. Coleman did not make the voluntary decision and that he did not demonstrate the definitive commitment to self-representation. It is clear from the very moment that he asked to go pro se initially that his preference was to have an attorney, and even then, after he was allowed to go pro se and then pleaded guilty immediately afterwards because he did not want to go to trial with that attorney and felt himself that he made a bad mistake in going pro se. And then, prior to sentencing, Mr. Coleman filed a pro se motion saying that he was forced to go pro se, and that impacted his guilty plea, and the court abused its discretion by denying that motion without conducting any inquiry of Mr. Coleman. And for that reason, we asked the court to reverse Mr. Coleman's conviction and remand for further proceedings, or alternatively, hold the appeal in abeyance and remand for appropriate consideration of that plea withdrawal motion. Thank you.
Thank you. Thank you both. Victor RMP versus Charles Condominiums.
Ready? Hi. May it please the court. This appeal concerns the limited issue of whether Victor RPM mistakenly annexed a wrong version of the governing contract.
How long was this mistake? How long does the mistake continue for?
The mistake was continued, I believe, for 4 years.
4 years, and how many decisions did the court make in that interim based on that alleged mistake in development agreement?
None that had to do with that actual development agreement, none where the development agreement, meaning which version was argued, none where the issue of which version of the development agreement was at issue, none of them had to do with that. So yes, it was carried over, but that's really a misnomer.
How many complaints were there?
I believe there were 2 complaints. This is an amended complaint.
And was the first complaint verified?
Yes.
And was the first agreement attached to that first complaint?
The other, yes, the other version of the agreement, yes, it was.
Right.
I'm sorry?
Who verified the first complaint?
I believe when the principals from the client, Ron.
So right, assuming that everyone did what the lawyer is required to have them do, that person looked at the agreement and decided that was the operative agreement and averred to that, correct?
You would assume so, but
Okay,
No,
no,
not
I
assume.
mean-
No, not assume, because there were two complaints, the original, the amended, and Corlick verified both.
yes. One thing though to keep in mind, please, is that both contracts are they're substantially similar with the exception of a few sentences, which is in section 10. It's not like we're dealing with two completely different contracts.
It goes even further,
I'm s-
right? Because also there was the council's affirmation, right, in opposition to the motion to dismiss. And I think that the agreement was twice attached. No?
You mean, are you talking about in earlier versions or the summary judgment motion?
Yes.
In earlier versions?
Yes. Okay. So that means yes, right?
I wasn't at the council then, but yeah, but yes.
Are both agreements signed, Agreement 1 and Agreement 2?
It's the same signature page for both. So obviously somebody, which we don't know who, took the same signature page and put it from one agreement to the other. One
I have another question. So, you know, that prior motion to dismiss, right? Did plaintiff ever dispute the authenticity of the agreement at any time?
in that prior one, no, but it never came up.
I just was asking.
No, yeah, that issue never came up. I
Wait a
understand-
second, so the piece that you are now saying is different in the second agreement is at the heart of this litigation, right?
Yes,
So somebody who looked at that first agreement would have looked at, presumably, if they averred that it was the truth, and they knew this is the heart of the litigation, they would have looked at it before it's swearing that it was all true and correct, correct?
it's the heart of the appeal. It's not the heart of the entire
Well,
litigation.
it's the heart of the dispute about whether or not money has to be paid right now, correct?
No, it's the heart of how much money has to
Okay,
be
how
paid.
much?
How much?
Right.
Okay,
As
you
far
can
as-
pick. You can pick it at, like at.
I
that
want to
if
get
you
back to the signatures. I thought that the signatures only appeared, or different signatures appeared on Agreement 1 and Agreement 2.
When you look at all the pages, it ends up to be the same signatures. One of them, the lower court believes some of them are whited out, but when you look at old versions of the agreement, they weren't whited out. It was just a bad
I
copy.
thought signatures on behalf of the defendants appear only on Agreement 2, and no signature on behalf of defendant appears on Agreement 1.
Oh.
Isn't that why it led the court to believe that there had been whited out?
The lower court did that. We're not saying that happened. The lower court believed that it was that they were whited out. We're not saying that happened. It was a bad version that the respondent produced, in the motion papers. When,
So
when
your
arguing that.
argument is that throughout these years of litigation, the complaint, the first verified complaint, the amended complaint, everyone was under the mistaken, the mistake or belief that they were referring to Agreement 2 as opposed to Agreement 1.
Yes,
And just so happens that Agreement 2 is more beneficial to plaintiff.
yes.
Yes, okay,
Could I point something out, though, please?
sure.
Instead of just taking our word for it, the lower court failed to address the extrinsic evidence, namely the emails that I've been relying on. There are emails from 2015 from general counsel for the respondent addressed to Mr. Karlik, where general counsel is admitting that it should have been Agreement 2. He's saying F, preferred class.
Counsel, to taking that email into context as opposed to all of the admissions that were made by submitting the same document over and over and over again. Do we really need to look to this extrinsic evidence? Do we need to look at that email? Because we have the contracts right here that have been continuously submitted, and now we can consider them as admissions.
At this early juncture, yes, considering there's no discovery and considering that you have the defendant admitting in an email, the same person who drafted the contracts, that F, and again, F is the key thing between both agreements, that F is out, that at the very minimum creates an issue of fact. This is a drafter of the contract.
No, it creates an issue of fact if you had put the document in first, right? But why aren't you stopped? Why aren't you literally stopped from claiming anything else after having used the first document for 4 years?
Because it was a mistake. Anyway, because they made a mistake. Yeah.
Just let me, is there anywhere in the record where the mistake is explained by the principal of the plaintiff? That I read the document, I misread it, or anything like that that we could maybe look at?
They did not, because it was brought up when we had the summary judgment motion. It was brought up in the reply papers, and then obviously I couldn't put in a surreply.
Was there anything explaining why he verified that not once but twice that was the operative agreement at all?
No, but I want to go back. I want to go back for a second. In the affidavits, there was an explanation, but the affidavits were disregarded by lower court. In the affidavits, there was an explanation that the proper agreement is the one that included Schedule F, and that this is not Mr. Karlik, this is Mr. Schuster, his partner.
But Mr. Garlick averred, right? He's the one.
He
who
averred, and
said.
Mr. Schuster is the one who signed the actual agreement. So he talked about when he fined when he was actually there, during the contract signing, that what he witnessed, what happened, so on and so forth.
These agreements were not signed on the same day, is that correct?
They believe that they were. I believe that's the same date. Like I said, I believe somebody did a bait and switch, because when you look at the actual paper, you could see like the same mark, like a black mark on a page. Everything the numbering's different, and people put it together different, but the actual pages themselves are identical.
Thank you. You have time on rebuttal, I believe. Oh, no, you don't. Sorry about that.
Good afternoon, Your Honors. May it please the court. Jeremy Cohen for respondent.
So what about the email? So your email saying, you know what, you guys are right.
Well, first of all, the email doesn't say it's that agreement. It says it was in the context of trying to figure out in advance a non-contractual payment. They were trying to accommodate Victor at the time with a payment that wasn't yet due. But I think the key legal point is it doesn't matter. They are stopped. Justice Scarpula used the word stopped. They are stopped. Okay, 6 times they swore to this agreement, twice in a verified complaint. In 354 Chauncey, which I believe Justices Weber and Singh were on the panel for that, the court said you're stopped from contradicting your pleadings. We also recently submitted supplemental authority, Carey versus Toy Industry, which this court decided on May 2nd. Justice Kennedy was part of the panel there. And what the court held there is that a contract that's annexed to a complaint is part of the complaint for all purposes. Facts admitted in the complaint constitute formal judicial admissions and are conclusive of the facts admitted.
And it's your client's position that the first document is the...
There's no dispute that that's the real agreement. If you look at what they put up as the new agreement, and Your Honor asked about signatures, in the real agreement, the one that they submitted 6 times and that we don't dispute is the real agreement, the signature pages signed by Moshe Schuster on behalf of Victor follows immediately from the last page of the agreement. It then has signatures for my client, Charles. It then annexes what I refer to as the Starwood Agreement, which is an assignment and subordination agreement. And in the agreement that they put forward, and it's in the record at 254 through 258, the signature page that immediately follows the text of the agreement is unsigned. 2 pages later, somebody tacked on signature pages, and there's no Starwood Agreement with it.
See, that's why I asked whether the agreements were signed on the same day or when they were signed, because it didn't really, it seemed kind of curious to me that if you're signing the agreements on the same day, you wouldn't just do the same signatures on both.
What I can tell you is Starwood was signed the same day. It's all part of the same package. Their new agreement that they found 4 years later doesn't have Starwood. And then the only other point
Was there anything below explaining how the document was used? I didn't see anything in the record on appeal.
There's not. No, there's no record evidence of what they call a mistake. It's a belated argument.
Other than counsel arguing it was a mistake.
That's all there is.
Is there anyone who put in an affidavit explaining how this could have happened?
There's no affidavit from Victor. There's no affidavit from Tartar Krinsky, who, by the way, is the firm that negotiated the agreement.
Right.
Mr. Ofsevic at Tartar Krinsky negotiated and drafted the agreement for Victor. He actually notarized the first complaint, and then the Tartar Krinsky litigators made all of the filings. So clearly, if anyone's in position to know what the right agreement is, it was Tartar Krinsky.
Thank you both. Next matter is People v. Rashawn Davis. Justice Pitt Burke is recused on this matter, so she will turn off her sound.
Good afternoon, Your Honors. Paris DeYoung of the Legal Aid Society, here on behalf of Appellant Mr. Rashawn Davis. In recognizing the severity of the underlying offense in this case, for an individual with no prior criminal history who turned himself into police, a sentence of 5 years incarceration and 3 years post.
There was some discrepancy in the record. Your brief stated that he turned himself in January, and the People's brief stated that he turned himself in like a couple of days looks after the incident.
Yes, Your Honor. All the documentation that I have seen provided by the people suggests that he waited until January.
That he turned
He didn't
himself?
in January. Yeah, it was a couple of months after the fact.
Okay. So now the defendant was sentenced to 5 years incarceration and 3 years post-release supervision, and you're requesting the minimum, which would be 3.5 years incarceration, and I think
2.5.
2.5 post-release.
Yes, Your Honor.
So why would we reduce the sentence?
Well, I think there are a lot of mitigating circumstances here that are quite significant and sort of stand apart from a lot of other cases. In addition to having no criminal record prior to the incident offense, and in addition to turning himself into police at his own volition, Mr. Davis, who is now only 26 years old, he was 22 at the time of the incident offense, has significant work history and has very close relationships to his community and his family, including to his daughter, his mother, and his grandmother.
So he fired 2 shots at the entrance to this bar that was located at Rockefeller Center, and I think it was around midnight, something like that?
Yes, Your Honor, it was around midnight.
Okay, so he just fired 2 shots at the entrance of this bar, Rockefeller Center, tourists, individuals walking by, etc. And this was based upon some type of dispute that he allegedly had with somebody at the bar, right?
Yes, that's correct.
So, I mean, it was quite possible that someone could have been injured.
It's absolutely possible, Your Honor, and I'm not here to dispute whether or not there was potential harm to an individual who may or may not have been walking by, but I think what's significant here is luckily no one was injured, which is a factor this court has repeatedly considered and I think should consider here in evaluating an excessive sentence claim. I also think my client has demonstrated a really significant rehabilitative potential that's unique. Again, he was working and has held multiple positions leading up to the instant offense. He was working at a Starbucks and then a juice press and was working at those places until he walked himself into the 9th precinct and turned himself in.
And he was working at those establishments when he fired the 2 shots at the entrance.
He was working at the juice press at that time, yes.
And the maximum is 15, right?
15 and 5, yes. I'd also like to briefly address the Less is More Act, Your Honors, because I know this court has often brought that up in excessive sentence cases involving post-release supervision. While it is true that my client may benefit from the Less is More Act and having his post-release supervision period reduced, the legislature did not intend for the Less is More Act to replace this court's broad plenary power to reduce a sentence where it is excessive in the first instance, which is the case here. Had the legislature intended to somehow curtail this court's power, it would have done so. And the act was enacted in recognition of the fact that lengthy post-release supervision periods tend to sort of overstay their welcome. They tend to do more harm than good after that first year. And we are asking for a reduction to the minimum, which would be 2.5 years. And under the Less is More Act, he would have 15 months of post-release. That's assuming that he is successful, which we feel would be really adequate in this case, both because we see that plateau of benefit of post-release supervision after the first year. The first year is when people are most likely to reoffend. But we also think that a lengthy period would be particularly onerous for someone like Mr. Davis, who is so young, has a young child who he wants to be more involved in her life, and is also really anxious to re-enter the workforce.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Robert Beltland for the people. It was touched on briefly during my adversary's argument, but I do just want to highlight the seriousness of the crime. There wasn't just an imagined risk that someone could have been shot from 4 shots being shot at the bar.
Was it 4 or 2?
So, Your Honor, on that matter, there were 4 shell casings found, but the complaint says there were 2 shots So I guess it's not entirely clear, but 4 shell casings seems to suggest that there were 4 shots. And what's more, in addition to this being shot out into the open at this bar, there was someone standing outside of the bar. It was the bouncer, or the security guard rather.
Right, wasn't he the one who said he saw 2 flashes?
Yes,
That's where I
that's
got the 2 shots from, right?
I think he actually just heard the flashes, at least.
And then he ran back inside?
And then he ran back inside. And I just want to highlight that, Your Honor, just because there was a little bit of a disagreement about that in the various briefs in this matter. Additionally, defendant himself did, of course, agree to the sentence. It was a fairly negotiated plea agreement. Although he did turn himself in eventually, he did the bare minimum of admitting guilt to get this plea deal that he now insists is excessive on appeal. But his admission of guilt is what got him that deal, and therefore it should not be disturbed on appeal. And of course, it was also touched upon that this was only 1.5 years above the minimum sentence he received here. He received 5. The minimum was 3.5 when he was facing a maximum of 15 had he proceeded to trial. And then lastly, because the PRS was touched upon, of course, this court still does have the power to reduce PRS in the interest of justice if the sentence is unduly harsh or severe. But it's not unduly harsh or severe here. It's only 6 months above the minimum, and because of the Less is More Act, it could be reduced to 1.5 years, more or less the time they ask for if he has good behavior. So unless your honors have any further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, I'd like to just briefly address my opponent's claim about the importance of the bargained for nature of a plea agreement. While the Court of Appeals recently in People v. Ba, those concurrences did seem to suggest that the bargained for nature of a plea may be a factor to be considered by an appellate court in evaluating the excessiveness of a sentence. Both concurrences made clear those are not dispositive. It's just one factor to be considered among all of the others, and I think in this case, given the substantial mitigation, the mitigation greatly outweighs whatever weight this court chooses to give to the bargained for nature of that plea. I also think it's worth pointing out that Judge Garcia in his concurrence expressed that the weight of a bargained for plea agreement should be greater in that case because there the defendant was given a choice between 2 punishments, one of which was community service, the other was which to pay a fine. My client obviously was not given a choice, and it was certainly a much more significant punishment than community service or a fine. And so I think in this case, any weight.
So you think that shooting a gun into an open space with someone around just requires an absolute minimum plea in the circumstances?
I'm sorry, a minimum.
Given the severity of
Yes.
what your client did, isn't that something that we should take into consideration?
Absolutely, Your Honors. I mean, the underlying offense and the facts around the offense are clearly something you all should consider. What I'm saying is that just the fact that he bargained for his plea agreement isn't by itself a reason for this court to not reduce, particularly in a case like this where we have so much mitigation, and also where, unlike the defendant in Ba, there was no decision being made. The defendant there was said, okay, you can do community service, or what was the other? Or you may pay a fine. And I think what Judge Garcia was pointing to was how minimal those offenses were, and the fact that the defendant was given a choice. It's harder to argue excessiveness when an individual had more autonomy in that decision.
Thank you. Thank you,
Thank you,
Bill.
Your Honors.
Shots v. Shertalk. Yes, whenever you're ready.
Good afternoon, Your Honors. If it please the court, Douglas Chertok for appellants. I have a 40-second opening statement. Justice Scarpula remarked in an interview that the good stuff is when cases involve underdeveloped New York law. This is such a case. This appeal boils down to one issue. The indemnification agreement is valid under Section 11.1d. Statutes and cases authorize contract indemnification broader than an LLC agreement despite a fee-shifting clause. International Rail involved identical facts, and its holding is dispositive. It says, quote, the existence of a fee-shifting provision in the LLC agreement, which expressly only applies to members, does not eviscerate the indemnification provision, end quote. Indemnification and fee shifting are based on different statutes and policies.
So wait, let's start with whether you could even do that amendment, right?
So under all of the New York Limited Liability Company Act 417,
Right.
under the BCL 721.
No, you have an LLC agreement, right?
Correct.
And what does your LLC agreement say has to happen for anything like that amendment to be enacted?
Respectfully, Your Honor, I would not call it an amendment because 11(1)D specifically provides for extra contract indemnification.
No. But what this says is you don't get paid. Of course it's an amendment. You don't get paid until the indemnification is paid, right? And it says, and to the extent that it tries to, I think, add on, because there's a section that says that if we sue each other, everyone bears their own legal costs, correct?
Yeah, that's in
And this is, we're suing each other.
Well, Your Honor,
And
that's...
the amendment that you're talking about changes that dynamic, correct?
Respectfully, Your Honor, I disagree. 14.7, which
Right,
was...
let's assume that I think it does.
Okay.
Right? Then what had to happen to have that amendment be effective?
11(1)D provides for it. It allows for additional contract indemnification.
No. And assuming that this is an amendment to the LLC agreement and not that it provides for it, what does the LLC agreement itself say? What kind of vote would one need to have that amendment be effective?
Well, Your Honor, respectfully, the cases of Marinkovich...
I don't think I'm being, let me interrupt you for just 1 second, because I don't think I'm being obtuse. I think I'm being pretty straightforward. Isn't there a requirement in the agreement who can vote on what and how big the vote has to be? So in this situation, assuming that I think this is an amendment, what percentage of the LLC members would have to vote to approve?
The provision that you're referring to, ma'am, does require for amendments to the operating agreement unanimity. However...
Was there unanimity in this amendment? Assuming that I think it's an amendment.
Assuming that it is an amendment, that there was not unanimity.
If I think it's an amendment, clearly we both agree it's not ineffective.
That's correct.
Okay.
But I would add that Marinkovich and in 417 of the LLC Act and in international law, it addresses that exact same provision, the same 14.7 fee shifting clause that's in the operating agreement, and it provides, as I said just a moment ago, the existence of a fee shifting provision which expressly only applies to members, same as 14.7, does not eviscerate the indemnification provision, which was the same indemnification.
Oh, I agree. If anybody else in the world sues you, you get indemnified. That's what it says. Anybody else in the world sues you individually or the other LLC member individually or the LLC itself, actually would have to be just you. The LLC would pay its own fees. You're indemnified, absolutely, does not eviscerate it. But there's two separate sections here. One says if we sue each other, we bear our own costs. The other one says we get indemnified if anyone sues us for our actions as members or managing member of this LLC. That's not inconsistent. There's nothing inconsistent about that.
Respectfully, I think Your Honor is drawing on the Hooper distinction, which I know you've opined on in other cases as well, but that applies to bilateral commercial contracts where you're dealing within an indemnification provision.
Why isn't this a bilateral commercial contract?
Because it's an LLC agreement.
So what? It's a contract between two people, right?
Yes.
To run a business. Why isn't that a bilateral commercial contract?
Because under the LLC Act, it allows for parties to contract however they like, and that's different from
you can contract, unless it's against public policy or a statute, any commercial contract, you can contract whatever you want, keep in or take out whatever you want, right?
The International Rail case speaks to this very exact distinction and draws a distinction between bilateral contracts and LLC agreements because they're provisions of or documents of contract that should be freely formed however the parties want to. And it has exact provisions. Its Section 10 completely parallels 14.7 of this agreement, and its other section, which I believe was 12, exactly parallels 11.1D. And it says the indemnification provision with the contract indemnification is perfectly allowed without amendment. It's not an amendment to the operating agreement. it's allowed because 11.1D is there. Marinkovic says the same thing in the third department, and that appeal was granted and allowed the contract indemnification.
You have time on rebuttal.
I'm sorry, Your Honor.
I said you have time on rebuttal.
Thank you, ma'am.
Thank you, Your Honors. Daniel Weinberger for respondent, Daniel Schatz. One first thing I'd want to note with respect to Hooper is that I do want to bring the court's attention to Sage Systems versus LIS, which was a case decided in October of 2022. I realize it's not in our papers, but it did involve an indemnification provision in a partnership agreement, and it reaffirmed Hooper's unmistakably clear language. To me, that's all besides the point, because this issue has already been litigated before the Supreme Court, before this court, multiple times.
Essentially, what your adversary is attempting to do is an end run around our decisions.
Yes, that's exactly what it is. I mean, we wish we never had to bring this lawsuit to begin with, but the whole indemnification agreement that he created after the decisions went all the way up to the Court of Appeals required us to bring this because it was attempting to do an end run around this court's decision in the last 2018 lawsuit.
And what was done here, was it an amendment, as my colleague is suggesting maybe, or not?
It was an attempted amendment. It was an attempted amendment.
What's your basis for saying it was an amendment?
Well, he was attempting to alter Section 14.7.
Essentially removing it. It's not altering it.
Yeah, it is. It is removing it. It's eviscerating it. That's right. The motion court got it absolutely right. I mean, from the main issue in this case, which is the indemnification agreement, that's void, but all of the other ancillary issues that were raised on the motion to dismiss were frivolous, and defendants raised several of them in their opening motion papers and then threw some of them back in reply. They snuck back in their 3-member argument that they're supposedly Vast Ventures LLC counts as 2 members and therefore has a majority vote to take certain actions. They made a judicial estoppel and equitable estoppel argument that have no applicability whatsoever here. And for that reason, we did bring a motion for sanctions. Frankly, we had to because the costs were getting enormous in responding to this appeal and the prior motion papers.
Well, you got sanctions below, right? You got your attorney's fees below.
Below, but not for
right.
the appeal. I mean, the appeal was an expensive endeavor to respond to, and we had no choice.
Put in those papers on the appellate record, in the appellate record?
I'm sorry?
Did you put in the appellate record the sanction papers below that would require?
Well, we did not create the appellate record. We did bring a motion for sanctions.
Below, right?
Right. Well, no, we brought a motion for sanctions of this court.
And that was granted below.
But we brought a motion for sanctions with this court on this appeal as well.
Okay.
We didn't create the record.
You didn't create a record for that motion, right?
Well, we didn't create the record on appeal. We did attach their appeal papers. I mean, we did attach their motion papers, I believe, to our motion for sanctions. I believe we did. But I think we did, but they're still available to the court. I mean, the motion papers themselves are available to the court, and Justice Schechter referenced the motions papers in her motion to dismiss hearing transcript.
Thank you.
Thank you. You're welcome.
Thank you, Your Honors. I want to draw attention to the fact
Can you
that
address your client's attempt to dissolve the corporation in New York and to reconstitute it in Delaware?
Sure, there was a power of attorney to do those 2 acts.
But can we agree that both states have to agree to that procedure?
Well,
I mean, Delaware might, but New York doesn't.
even if that's the law, Your Honor, then under the power of attorney, the manager had the ability to go and convert to a Delaware entity.
No, but in a different, not by just reconstituting. That's the point. Both states have to agree to that process. Otherwise, you could dissolve in New York and then distribute and then start a new LLC in Delaware, which is the way that most people do it, or they do it by merger, right? They merge the two, a Delaware corporation into a New York corporation. But because New York doesn't consent to the way that your client reconstituted the corporation in Delaware.
Yeah, actually, under the New York chapter, I think it's under 701. I might be misquoting that. I apologize if I am. That it provides that within 60 days after a company has been reconstituted in another state, that it should dissolve. And so we did follow those parameters. Regardless though of the
I think the law in New York is that you cannot, the only way that you can move a corporation to Delaware is to merge it with another corporation or to dissolve it first and then start a new corporation in Delaware, which is a different process than what you did.
Regardless of the procedure, we had a power of attorney to undertake that procedure.
Okay, but if it's not a good procedure, it doesn't matter if you were the Queen of England. You still can't do it.
And
right?
whether or not the company remained a New York or a Delaware company, it had the ability to enter into the indemnification agreement. The only other point that I wish to raise, Your Honor, in closing, is that under the statutes that were mentioned, the cases from the Court of Appeals in Baker, Marinkovich, all of the cases in Delaware, Citadel, and so forth, none of those were addressed by the motion court, and none of those were addressed by the plaintiff. And the fact that the company cited all of this case law, but yet the defendant did not, or the respondent did not, it's extraordinary that it can't be considered as a function of law to do those things when they're statutorily and legally sound, according to all of those cases.
Thank you.
Thank you, Your
both.
Honors.
Last case for argument is Ballantyre Corporation versus SNRP West.
May it please the court, Your Honors, Thomas Satilli on behalf of Appellant Defendant SNRP West 37 LLC. In this action between a sophisticated commercial tenant and landlord, the trial court erred by failing to order tenant respondent to pay rent, use and occupancy or rent, pendenti liti, or to post an undertaking as a condition of its Yellowstone injunction. The court misinterpreted the status quo between the parties to mean that the tenant may remain in possession of the premises, have unfettered possession and control over the premises, yet be free of any obligation to pay rent or use and occupancy or to operate its business.
So in the record, the tenant put in an affidavit that said that we were closed down, and then after that, the hotel was used as a homeless shelter and for storage.
I'll address that in two parts, Your Honor. First, even assuming that the tenant's deficient affidavit to that effect was true, which it certainly, on the moving papers for the Yellowstone injunction, does not adequately allege. On page 11 of the record, you can read the affidavit. Even assuming that that's true, the error in the court's order was that the court jumped to the end game. The court awarded essentially the declaratory judgment that the tenant seeks in its complaint, to wit, that the tenant was not in default and that the tenant...
I don't think anyone thinks that. So, I mean, you have the right to go back and seek UNO anytime during, you can go back today and say, the tenant's running its restaurant, I want UNO, correct?
Well, I'm sorry, could you repeat that?
You have the right to go back and seek UNO going forward at any time.
The problem is that the court did not condition the issuance of the Yellowstone injunction upon
Okay, so what the court said is, as they usually do in Yellowstones, is The tenant has raised an adequate defense. I'm going to keep the status quo. I'm not going to let you terminate the lease. And if the court didn't award UNO, you can always go back and ask for it.
But that's precisely the issue. The status quo is not that tenant remains in possession of the premises
it is.
without paying rent in
So
exchange
go
for
back
that.
and ask for UNO.
The problem is that in addition to UNO, the court failed to, in accordance with the Gap case 2 years ago in June that this court issued, failed to order the tenant to post an undertaking that's key
Is that a requirement in a Yellowstone?
It's in the Gap case. It was ordered. It's
Isn't
typically
that ultimately a discretionary decision
it's
by the judge in a Yellowstone? Not under the CPLR. I'm talking about a Yellowstone is essentially is a judge-made creation.
right. It's discretionary only where it's discretionary, but it's ordered in cases where there's no dispute as to the fact that the
Except in this instance, there's an affidavit from Doyle saying what my colleagues alluded to, and also the premises are being used for storage, which may or may not be true, but wouldn't you need to make a full record of that now down below, saying the premises are completely available for the restaurant to start? And then if you are correct, presumably the court would then make a determination as to UNO.
The only cases where UNO or an undertaking is not required is where there's a question, that the tenant raises a question as to whether its obligation to pay rent under the lease has been triggered. In other words,
Isn't that what the tenant did here by showing that the property was
No.
effectively not being able to be used?
What I mean by that is whether a condition precedent to the payment of rent
So in
the
other
lease.
words, if Doyle's affidavit is correct, that as of today, the premises can't be used because you're using it as a storage facility, your position is that the court would be required to order use and occupancy?
Right, the court would either be required to order use and occupancy or
And
an
that's based on what?
I'm sorry?
What is your argument based on? You're using it as a storage unit, a facility. They cannot use it as a restaurant as they wish to do. So I'm not understanding why there would be an undertaking.
In the event that it is borne out in litigation through discovery that the premises was not used as a storage facility or the tenant's right to possess was in jeopardy, the undertaking exists to provide sufficient surety in place for the landlord so that, say, the tenant declares bankruptcy at the end of the litigation, the landlord isn't left holding the bag, which is exactly what the decision.
So why don't you just go to trial? Why don't you just make this a fast trial? This is not a complicated case. If that's what you're worried about, we all agree that the undertaking is discretionary, and frankly, you didn't put anything in on the UNO. So go do it.
And I thought that Doyle's affidavit also included photographs showing that it was being used as a storage facility.
On the initial application, respectfully, Your Honor, I don't think that the photographs pertaining to the storage facility were attached, but even if it did, and we would love to go to...
Could you just answer a simple question? Were the premises being used for storage, yes or no?
Not to my knowledge, Your
Not
Honor,
to,
no.
well, then why didn't you put an affidavit from someone saying the premises aren't being used for storage? Here are the photos of what the premises look like.
In opposition, we say that the premises are available to the tenant to operate its business.
Where?
In opposition to the Yellowstone, and there was successive motion practice in the record.
No, we only have a record. We don't have a record with anything from anyone with knowledge saying that.
To pivot back to your question about why don't we just go to trial, we would love to go to trial, but by the time we get onto the trial calendar, the tenant can be gone.
Make a motion for UNO. If the restaurant is running and they're making money without paying you UNO, make a motion for it. Make a motion to modify the Yellowstone. You have a million remedies.
If the tenant disappears overnight while our motion is pending, that's what the undertaking is designed to remedy.
Ifs. That's an if, but you have these remedies, which I'm not understanding, and I still don't understand why you simply didn't submit an affidavit or something stating, no, that, it's not being used as a storage facility. You're stating that your affidavit stated it can be used as a restaurant. Doesn't really, it begs the question as to what would be necessary in order to, for it to be used as a restaurant. If it's being used as a storage facility, you'd have to totally clear it out. You'd have to start all over again. So I'm not understanding the record.
The issue is that if the tenant disappears overnight, we're left holding the bag while we're on
pertains to the undertaking. That pertains
Yes.
to the undertaking. I think
Correct.
we're talking about use and occupancy, but the problem with even the undertaking, as you've acknowledged, this is a Yellowstone injunction. It's a discretionary decision, and Doyle's affidavit raises, at least on this record, a colorable defense of why rent wasn't being paid, and that's not what was addressed by you before the motion court.
Well, I respectfully, Your Honor, I do.
Have time on rebuttal. Thank you.
Okay. Thank you.
Good afternoon, Your Honors. James Berger for Respondent Ballantyre Corporation, and may it please the Court. Your Honors, we ask that you affirm this decision.
So why aren't you paying UNO?
Your Honors, first of all, we stand behind our affidavit.
No, that's, yes, of course
But
you do.
I can explain that.
Is the space open for business?
It is not.
It's still being used as a storage facility?
Yes, it is.
And, okay, so,
What I think might help the Court is if I could divide this into 3 separate time periods.
I'm wondering why going forward, if you still want the lease, you're not paying UNO?
So we are absolutely
What's stopping you from using the space as a restaurant, I guess is
that its fundamental character was converted, changed, that is, during the period in which it was
is the hotel going forward now? Is it a hotel?
The hotel portion of it is operated, but the damage caused.
No, but that's
to
forward. We're
the
talking
other
about
portion.
UNO going forward. Is the hotel operating now?
The hotel is operating now.
And there is the space cleared for you to use the restaurant?
No, it is not, Your Honor.
Oh, there's there's bags and stuff still in there?
That's correct, and we have pictures to this effect as well as video. In fact, we're going to be in front of Justice Saunders tomorrow on a motion for contempt because we believe roughly 5 months ago at
So that's
minimum,
outside of the record.
Fair enough. Additionally, however, when you've asked about what other remedies that they might be pursuing, Justice Saunders will also be hearing tomorrow a motion to re-argue, making the same points here, and a motion to renew. So our
what's your
position is that they
position
have
as-
other opportunities.
What's your position as to the undertaking, because you could disappear overnight?
Certainly, Your Honor. With regard to the undertaking, Yellowstone injunctions are indeed not equivalent with regard to all other preliminary relief, which is indeed governed by CPLR and certain other bright line rules. Yellowstone injunctions are creations of judicial discretion. And here, Justice Saunders carefully crafted a Yellowstone injunction that reflects the appropriate principles. We've cited numerous cases in our briefs where Yellowstone injunctions were granted, but neither undertakings nor rent use occupancy were required, and that was based on the facts. And here, where you have had a issue regarding frustration of purpose of the contract, and that's ongoing, as well as when you have issues related to the fact that my client, and this is sworn to in multiple affidavits, invested substantial funds in the property. Those are 2 types of cases where courts have typically not ordered undertakings or strict rent use and occupancy. So we would not dispute, for example, that the Gap decision cited by my friend here was wrongly decided. It's just that it was decided by using judicial discretion based on the applicable facts in that case. My client...
What I don't understand is, if you don't want to use the property as a restaurant, why not just hand over the keys and litigate whether or not the back rent is due.
There are two issues there, Your Honor. First, a client, from the time that this ceased being used for these alternative purposes, stated a willingness to re-enter and reopen, but asked that there be at least some accommodation so that it could be restored to its prior condition before it had been used as a COVID hospital / homeless shelter. That never happened. Instead, two things did. Number one were threats by appellant to sue my client for back rent, even for the period in which the property was unavailable. That's about 1.5 years. And secondly, a refusal to engage in any further communications. So it was at that time that my client filed a lawsuit seeking this relief, which was ultimately awarded in October of 2022. The other reason, however, is that the restaurant and bar business it's distinct from a lot of other businesses. A lot has gone into creating this particular Irish pub that had been thriving, not just for the hotel, but as a part of the neighborhood. And that involves hiring staff, finding the right chefs, getting the right food, restoring all sorts of other changes made to the premises. And so we ask, based on those grounds, that this court respectfully affirm Justice Saunders' well-reasoned decision.
Thank you.
Thank you, Your Honors.
Thank you, Your Honors. I just want to say we would be more than happy with payment of UNO into court as escrowee, the undertaking paid to court as escrowee, which is often awarded in these cases. To address my friend's point here, the space, this is not in the record because this was developed after the appeal was perfected, but the space is available and in pristine condition. I've personally been in there. The frustration of purpose was rejected by the Gap Court as a defense to the payment of use and occupancy. And as to your question—
Counsel, but and maybe you're right, maybe you're not, but the problem is that it's not before us in the record, and so we're sort of bound by what we have. And we have Mr. Doyle saying certain things and nothing disputing that. And that's really what we're stuck with, and you're stuck with.
We do dispute that the premises were unavailable for use as a restaurant for the duration of the period where the tenant has not paid rent, which was years.
And as my colleague pointed out to you, you have tons of remedies in Supreme Court now to address those issues.
Which you'll be able to do tomorrow, apparently.
That does not solve the question of whether, say the court on our motion to renew takes 6 months to render a decision. The tenant, again, can disappear, and we have no sufficient surety in place. But I'd like to answer Your Honor's question. Why don't they just vacate the premises, which is a good question, Your Honor. The clear answer is that they're hoping for a generous buyout. They're using the Yellowstone as a means to hold the premises hostage, and it's a tactic that they're free to use, but that's why they haven't vacated. They're hoping that we'll just pay them to go away. Unless Your Honors have any further questions, we rest on our brief.
Thank you. Thank you both.
Thank you.
Thank you.
That's the fun part.
You're gonna stop.